Thank you. This is the Sunshine Ordinance Task Force Compliance and Amendments Committee meeting, regularly scheduled Tuesday, February 9th, 2010. Roll call, please.
Yes, Madam Chair. Member Craven Green?
Here.
Craven Green present. Member Nee?
Here.
Nee present. Member Washburn?
Here.
Washburn present. Member Johnson?
Here.
Johnson present. Member Goldman?
Here.
Goldman present. Madam Chair, there is a quorum.
Thank you. I've had no request for agenda changes, so item 1.
The first item is the approval of the January 12, 2010 meeting minutes.
Thank you. Is there any member comment?
I just have a couple of typos on the first page. Under item 2, third paragraph, Respondent Olive Gong, custodian records for the Department of Recreation and Parks, said the department. I think there should be a comma after department, according to Ron Vincent. And then on the next sentence says, on Terry Schwartz's emails, a search was done and 43 pages worth was provided to Ms. Mabbitt. I think it should say 43 pages worth of something, of information, of documentation. Or...
Emails.
Emails.
Okay, maybe emails then, yeah. Maybe that should be in there. That's all I've got.
Member Washburn?
I just have one on page 7, item number 3, second paragraph, middle of the paragraph. I think there should be a comma after Microsoft Exchange program to help clarity. And that's all.
Thank
I
you.
move that we accept the minutes as amended.
I second it.
Is there public comment on the minutes? Seeing none, public comment is closed. Roll call.
On the minutes, Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Johnson?
Aye.
Johnson, aye. Member Goldman?
Aye.
Goldman, aye. Member Craven Green?
Aye.
Craven Green, aye. Madam Chair, there are 5 ayes.
Thank you. The next item, please.
Item number 2 is the hearing on the status of the December 1st, 2009 order of determination of Anne Marie Mabbitt against the Department of Recreation and Park.
Thank you. And I don't see Ms. Mabbitt in the audience. Mr. Rustum, have we had any communications from her?
Madam Chair, as instructed, I did send her an email asking her for additional evidence, and that her response is in the agenda packet.
But when you send out the reminder of the hearing, did she respond?
She did not respond, Madam Chair.
Ms. Gong is here, so we'll take this item. Ms. Gong, you have 5 minutes to tell us on the status of your compliance with order determination.
Good afternoon, members of the Compliance Committee. My name is Olive Gong, Custodian of Records at Recreation and Park Department. So far, we have compiled with Ms. Anna Mabbitt's request for Terry's emails by providing her the emails that she had requested, the 43 pages of emails that we had sent her November 4th. We had copied the Sunshine Committee at that time also. And then I emailed again these emails on January 1st to the committee and also to Ms. Mabbitt again. Regarding the audio online request, Ron Vincent, the Director of Media, has stated that he's working with our staff for implementation for this fiscal year. So those are my comments.
Thank you.
Welcome.
And I made an error. I wanted to ask if there's anyone here to present facts and evidence on behalf of Ms. Mabbitt. I didn't see anyone. Seeing none. Ms. Gong? Have you talked to Mr. Vincent about the update since the last meeting?
Yes, he said that he doesn't have any further updates. Yeah.
Okay, so their expectation and hope is to have that capacity by the end of this fiscal year.
Right.
Okay. With respect to the Schwartz emails,
yes,
we did receive some correspondence from Ms. Mabbitt on February 2nd, and I think you were CC'd on that. And in response to our request that she provide evidence of the specific emails that she claims were not produced in those 43 pages. And she only notes one, an email sent by Ms. Mabbitt to Terry Schwartz on Tuesday, October 24th. Was that, we really don't know if that email exists because we haven't seen proof of that, but was that email included in the 43 pages?
Actually, I didn't check it, but, everything that we had given her, we had copied your committee also.
Right, so I don't have that in front of me. Did you happen to bring those 43 pages?
No, I brought them the last time.
Yeah, I understand that. All right, maybe we can ask Mr. Rustin to go get those. Did other members have questions for Ms. Mabbitt about the posting? So we'll just be 1 minute.
All right.
Ms. Gong, actually, can I ask one more question while you're here? What's the date, again, I know you just said it, but I missed it, the date that you provided the initial response?
Sure.
And if you could use the microphone.
I had emailed the Terry's emails on November 4th,
November 4th, thank you.
2009. I had copied your task force at the same time.
Thank you.
Welcome.
And Ms. Gong, I'm sorry, we're just looking through these right now because I just got this February 2nd email recently, so I didn't have your packet before me. It looks like most of the email you produced in these 43 pages is from 2009. There's one from 2008. Actually, there's a couple from 2008.
Yeah, these are we had done a search through his emails, and these were the only documents that we found. Because he had been, he's no longer with the department. He himself did not look for these. Yeah.
Right. Were there any emails from 2007?
No, these were the only emails that we found. Yeah.
All right. Did the department have any procedures in place with regard to deletion of email during 2006, 2007?
We do have a record retention policy.
And how does that apply to email correspondence regarding permits?
I don't know for sure. I imagine it's the same as with other documents, other emails. That permits would be would fall under the same rules.
And what would that be?
Emails. I don't have the record retention policy with me. I think in general documents are supposed to be kept 3 years.
Okay.
But I can email you our record retention policy if you'd like.
Right. So you see kind of the difficulty we have. The emails that you produce are there are a few from the end of 2008 and some from 2009, but there are none from 2007, none from 2006.
Yeah, the further back, the harder it would be to find them.
Right. What email system?
We use Lotus.
What system? Lotus Notes.
Yeah.
And when the search was done in Mr. Schwartz's remaining emails, or how did you keep that once he left your employ? Our
IT guy said that he searched in his computer. I I believe he said he searched in Terry's computers to look at the email files that were there. And that's how he found these emails.
And so, even though Terry was no longer with you, you kept
Right.
his computer, the hard drive, or?
I mean, either there was a physical computer or there was, data with, I don't exactly know how he did it, but he searched through what, I could ask him again and email you the response. I could ask our IT person how he searched and found those emails.
Yeah, that would be helpful for us. Kind of what we need to know is what reasonable steps the department take to do the search. How would it have been that we only have emails from 08 and 09 and nothing from 07 or 06, which under the 3-year policy should be.
I think Terry was only with us for 2 years.
that would be an answer.
He was not, he was recently hired and he only lasted 2 years before he was let go.
Okay, I'm just saying Ms. Mabott, who's not here,
Right.
indicates that she sent a specific email on Tuesday, October 24th, 2006 to terry.schwartz@sfgov.org.
That's a long time ago.
It was a long time ago.
Yeah, and I really do believe he was only with us for 2 years.
But he was there during that period?
No, I work in the department and he's down the hall. And this is what I've heard, you hear things, he was let go and, he was working here only 2 years. But I can totally look that up for you.
Right.
Yeah.
Clearly, if he wasn't a government employee in 2006,
Right.
then Ms.
I know-
Mabott wouldn't have any
I know he came from the private sector.
evidence.
Yeah,
there would be no emails.
I didn't put those two things together when she mentioned
And I understand
the
you have a
two.
lot of requests, so there are a lot
Yeah.
of pieces you're keeping in track of.
Yeah,
All right, well then, maybe what we can do
Okay.
is if you could please find
Sure.
out
his date of employment.
his date of employment,
Sure.
what dates he was there from,
Okay.
and then ask your IT guy specifically,
Okay.
what did he do to search the emails? Were they located on a physical hard drive? Were they a backup of data information that was assigned to a particular user?
Okay.
Um,
I know that our IT guy said that he looked for 2 hours looking through all the emails.
Yeah.
So that it was a search on his part.
Right. And along those lines, which email or search criteria did he use? Because that might be it too. If he didn't search, if he searched for Ms. Mabbott's name, but not necessarily from the 3 email addresses that she provided.
I know he said that he looked at all the emails that she asked him to look through to search. Yeah.
All right, well, if you could just get that in more of a
Okay.
detail in writing, then
Sure.
we'll be able to make an informed decision. But without that information,
Okay.
we really can't,
Okay.
unfortunately.
Sure.
So I apologize. And we will restate to Ms. Mabott, we will continue this. I guess what we'll do is we'll continue this matter to the next hearing. We will ask Ms. Mabott to please provide the hard copy evidence of these emails that you say exist that haven't been turned over. I will maintain this copy, so I'll be able to double check it before the next meeting. But if you could provide the information from your end
Sure.
as to how the emails were kept, what the record retention policy is for this type of correspondence, and how the emails were searched physically and under which terms,
Okay.
we'll be able to bring this matter to a close.
Okay, great. All right.
Any other further questions from members? Public comment on this issue?
How you doing? I couldn't help but listen to the...
Microphone?
Oh, I'm sorry. I couldn't help but listen to the dialogue that was going on, and I just wanted to say, based upon my getting information under the Sunshine Ordinance, that most organizations have servers or backup servers. So I don't know if this is a city organization or what, and I'm reading a book about networking, and I just wanted to say that based upon my knowledge, I think city agencies or governmental agencies are required to back up all the emails and information, because technically the emails do not belong to the employees, they belong to the agency, because the agency pays for them. Thank you.
Thank you. Any further public comment? Seeing none, Ms. Gong, you have 3 minutes to respond if you'd like to say anything additional. Thank you. Seeing none, this matter should be continued to the next meeting without objection. Next item, please, Chris.
The next item is the hearing on the status of the December 1st, 2009 and January 5th, 2010 orders of determination of Asian Law Caucus against the Mayor's Office.
Thank you. Is there a representative from the Asian Law Caucus here? Seeing none, is there a representative from the Mayor's Office here? Seeing none, Chris, did you have communication with either party about this matter?
I did remind them that the meeting was coming up on Tuesday, and that was sent out on Thursday, and there was no response.
Right, thank you. Is there anyone here to present facts and evidence in support of the complainant? Seeing none, is there anyone here to present facts and evidence in support of the Mayor's Office? Seeing none, committee members, how do you wish to proceed?
Madam Chair, I would suggest that we, at this point, take any public comment on it, and after that, just continue it to next month. It's kind of regrettable, particularly that the Mayor's Office has declined to send anybody. We've informed them quite clearly that this is something we take seriously. It is a violation of 67.21E. It shows a lack of respect for the process and for the task force. And I think we should take that into account if and when we ever reach a conclusion on this. But for the moment, particularly without the complainant here, I think probably our best course is continuation.
What are our alternatives to continue? What would be our alternatives?
Our alternatives could be to decide to refer this matter back to the full task force for consideration by the Ethics Commission, or take no action.
Or dismiss.
We don't really dismiss, we just decide that there's been compliance, or we take no action.
I would make a motion to refer it back to the full task force
For
the Ethics Commission.
for a finding of willful failure under 6734 and 6730C, for finding a violation.
Yes.
I'd second that.
Been moved and seconded. So further, Member Nee?
Yes, there are other violations here, and if we're going to send this up to ethics, I suppose we could include that in anything we do with the full task force, but I would think that perhaps a friendly amendment is in order here to include the other violations, 67.21E and 67.27.
The maker accept?
Yeah.
Second
Think so.
accepts?
So the referral would be, this is the referral to the, move back to the full task force for potential referral to the Ethics Commission for willful failure to comply with order of determination, willful failure to comply with the requirement to appear at hearings, and willful failure to provide justification for withholding.
Yes.
Here's my concern. Was there or was there not a finding at the full task force, I wasn't there, that the Mayor's Office had in fact withheld documents? Because that is not reflected in this order of determination. So right now the referral would be for the following: failure to appear, failure to provide justification for withholding, and I'm not really sure what the order of determination means by violation of 6734 for willful failure to comply.
Madam Chair, are you looking at, there are two orders of determination here.
I'm looking at the second order of determination.
Okay. I just wanted to clarify that.
I mean, I'm fine. I wasn't at that meeting, and I raised the issue in the drafting of this order of determination, which I thought had been resolved, but it had not been resolved, about whether or not there was a finding that the Mayor's Office had documents or evidence that hadn't been produced, or that because they hadn't appeared to explain whether or not there really were documents that existed that had not been produced, that an inference would be drawn to that, to find that.
Madam Chair,
Member Nee.
I don't believe the mayor's office ever claimed that the documents not produced did not exist. The mayor's office, I think, has consistently held that because it provided that first set of documents, that met the request. But I think the task force came to the conclusion that this is my recollection, anyways. The task force concluded that because the second set of documents had not been provided, and because no justification for withholding had been provided, this constituted a violation.
What were the second set of documents? That was the issue. At the first hearing, the issue was we have a request for this policy, and we have a request for all documents showing how the policy was disseminated. What was produced was the memo, the policy.
Yeah, the memo.
And there was nothing else produced, and they said this completes our response. Now, they're only in violation for withholding if other documents exist. And we had no evidence that other documents existed, and we couldn't ask them about that because they didn't show up.
Right.
So I'm confused. I just want to make sure if this is something that's going to go to the Ethics Commission, that it's clear and that we've explained it. Member Washburn?
My memory is that because they would not appear at any hearings, that we could not, we had no evidence for that issue, of whether these documents existed. So we couldn't make a finding on that explicitly.
But we've got them on the 21E regardless.
Right.
Okay.
Right.
All right. Well, that's fine. And if that's the case, then that is clear, and that our referral will be would include that finding. The failure here that we're going up on is basically a failure to appear.
Right.
There was a failure to provide justification for withholding, but we really don't know if that actually happened or not. But that's why I voted against that at the prior meeting. And that what we would explain to the Ethics Commission is we couldn't actually determine if there were documents that had been withheld because no one appeared before the task force to explain how, in fact, this memo regarding the citizen sanctuary, constitutionality of citizen sanctuary legislation had been produced to the San Francisco Chronicle. Okay?
Right.
So as long as that's clear in our presentation back to the full task force and in the referral, then I'm fine with supporting the referral. I just need to have that clarified because it wasn't clear in this order determination. Any further comments? Public comment on this item? Roll call on the motion, please.
On the motion, Member Nee.
Aye.
Nee, aye. Member Washburn.
Aye.
Washburn, aye. Member Johnson.
Aye.
Johnson, aye. Member Goldman.
Aye.
Goldman, aye. Member Craven Green.
Aye.
Craven Green, aye. Madam Chair, we have 5 ayes.
Thank you. Next item, please.
Item number 4 is the hearing on the status of the January 5th, 2010 order of determination of Melvin Banks against the Department of Public Health.
Thank you. Mr. Banks, you have 5 minutes to explain to us the compliance or the status of compliance with the order of determination.
Okay, there's a couple of things I want to discuss, not only the compliance, but also in the fact that I think the mistake was been made when they sent 09077 to the Educational Committee, but according to the minutes that I have, it was supposed to have been sent to this committee. So Chris told me that I was supposed to bring that up also here. So let me talk about 09082. 09082, I have received some information from the Department of Public Health, Ms. Shields. She kindly forwarded some information. I think it was 2 documents. One was the local share mandate policy from the state, which was exactly 1.5 pages. And then a letter from her, from Barbara Garcia, who is the Department Deputy Director of Public Health, to the state asking for this local share mandate policy. However, the documents leave out some things which I thought were germane to me wanting the privacy board meetings open in the first place. I was hoping to find out why they put this mandate in force. What was the justification? There are always trade-offs in these decisions. This policy harshly reduces the privacy rights of people involved. Why do they feel what do they gain by what do they feel that they gain in this exchange? What is the advantage of limiting people's freedoms? This is not spelled out in either of the documents that I received. And since the meetings of the Privacy Board have been held in secret, this information is not spelled out anywhere. The public has the right to know the reasons why these decisions were made, the content of the discussions leading up to that decision that so harshly reduces privacy rights of clients involved. They did forward some information. It was from Eileen Shields. She's the, I think, the public information officer. I didn't request those documents. She forwarded them on her own, I guess, at seeing that there was going to be a hearing. Needless to say, I would like more. I think it's 6253.1, which is, you know, they're supposed to assist you in finding out what documents that you wanted. I think that's under the California Public Records Act. Anyway, I haven't received any word from them, or maybe I'm supposed to contact them. I'm sure of the protocol that was supposed to be followed to garner more information. So I have received something, but to me it's really doesn't explain why they adopted this mandate. As I said before, this mandate singles out people with HIV. As far as my research is concerned, I haven't been able to find any other disability, any other disease, or any other requirements for anybody else in the city and county of San Francisco that has this requirement to share their information or to violate their privacy. I guess that's it for this part. I would like to speak to the mistake according to the minutes, and I don't have the, I guess it's the draft minutes that were read at the last full task force meeting. Anyway, if you go to my complaint 09077, it says motion to find violation of 67.4 Washburn Goldman. On the motion, ayes Manna, Washburn, Nober, Chu, Chan, Goldman, Williams, Nee. Matter to be referred to Compliance and the Amendments Committee, which is this committee. However, I was informed that, this is for 09082, but 09077 was also supposed to be sent to this committee in regards to compliance for the Privacy Board to have their meetings open, since their meetings were considered a passive body. I'm pretty sure it was an oversight, because what we did, we started with, I believe it was 0977, and then later we combined 09082. And so I think there was a little mix-up, but I think both of them were supposed to go to this committee, and one went to the Education Committee, which I will not be able to attend that meeting. So hopefully we can, if you want to schedule the compliance meeting next month for 09077, I'll be more than happy to show up then. But I really believe it's more of a technical oversight. Thank you.
Thank you, Mr. Manx. Is there anyone here from the Department of Health to respond? Chris, do we have any communication from the Department of Health?
I did send them the notice that the meeting would be here today, and I did not receive any response.
Task force members? Or Compliance Amendments Committee members? Member Washburn?
Well, it looks like that Mr. Banks received some documents, but it's not clear that he was provided the assistance that he needed to identify other documents.
All right. Again, I wasn't at this meeting, so I'm a little bit at sea. Anyone else on this committee who was at the meeting would like to follow up? Yeah. Mr. Banks, I do have a question for you.
Yes.
So what you had requested in your initial request was a copy of the San Francisco share mandate policy relating to the new ARIES reporting system.
That's correct.
Is that correct?
Right.
And have you received that?
I received a copy of the state's policy, but I've never received the documents or the impetus that's led up to the development of this local share mandate policy here in San Francisco. In other words, I received the form, I think the policy number 3, which they sent from the state, that's just the state outline of the requirements that are needed for a city and county to apply for the application. However, my concern is that since this is not a statewide application of policy, in other words, counties have the option of either using this kind of local share mandate policy or not using this local share mandate policy. I wanted to know what were the policy decisions that led up to San Francisco adopting this policy. Now, maybe that wasn't clear, and I'll have to bite the bullet on that one. I wasn't clear. In fact, I thought that the policy would explain why they decided at the local level the thought processes behind applying for this state application. Unfortunately, these documents that they sent me is just pretty much 2 form documents. One is Barbara Garcia requesting that the state fulfill her request. The other one is just a list of the criteria that she needs to follow in order to make the request. So that's really not enlightening as to why this county and in this city has kind of gone against the community or client-centered model. I mean, San Francisco, as far as I know, is the paradigm for protecting people's rights.
Right. And forgive me if I don't quite understand. DPH did say that they provided you with a copy of the local share policy with regard to the RGGI reporting system, but stated there was no local share policy with regard to the ARIES reporting system. So do you agree that there is no local policy with respect to the ARIES reporting system?
I think there is a local policy because they had to decide how they're going to implement it. And what were the reasons? What caused them to? I mean, there has to be some sort of communication between people within DPH. What was the genesis of the ideas that led to this local to even apply for the application? Is it because it's a cost-cutting thing? Does it provide?
No, I guess I'm confused because basically you had a request and they said that there is no document.
Well, they vacillated. First, they said it was a share mandate policy. I don't have the email chain with me, but if you review the email chain, and I don't know if you have it or not available, first they said they had it, then they said they didn't. Then the guy said, "Well, I wasn't around when they developed it, and so it wasn't on my watch." So and then one lady says, "Well, I was referring to the local share mandate policy, but I was really referring to the state policy." But if what the task force is suggesting that I need to make a more precise request, then I'll go back and make a more precise request.
I think that's perhaps what needs to be done because the request was very narrow. Mm-hmm. And they basically said, we don't have that. We may have something else, but we don't have that. And the task force did find them in violation of failure to helping you.
Right.
Say, well, we know we don't have this, but we have this.
Right.
And so that is a violation. That will stand as a violation.
Okay.
But if there are specific categories of documents that you want, like documents that led DPH to decide to have a local share policy under RGGI and decide not to have a local share policy under ARIES or decide how to comply with the state policy under ARIES, you need to make a request that's broader so that you can get that kind of background information. That doesn't seem to me to be within this order of determination.
Okay. May I say something?
Yes.
What I'll do is ask them to assist me under 62.53. I'll ask them, I'll send an email, carbon copy you guys, and ask them to assist me in order to make a more precise and informed request. And then we'll see what happens from there.
Right, but make sure that you give them the background. Say, this is the kind of information I want to get to.
Okay.
Therefore, what do I need to request to get to that information?
Great. I'll contact Eileen Shields. And if you want next month, I can come back on the other thing. So I don't know how that works. So
On that issue, I'll ask Chair Nee to address the issue of the referral of the other complaint.
great, thank you. Okay.
Well, my recollection is that the other complaint dealt with that was an open meeting violation, right? It was,
I believe so.
and I don't think that we could really help. I don't think that this committee could really help on an open meeting violation. In other words, if it's a public records request, you go ask for some data. They refuse to give it to you, or they're, if they violate the Sunshine Ordinance on the record side, and then the task force and this committee, the Compliance Amendments Committee, can follow up and direct the respondent agency to produce the record, produce the document that you requested. But if a meeting has been held, if there's been an open meetings violation, you can't go back and correct that. You can only look going forward, and that's something that this committee would not be able to do. That's something that the Education Committee would then be charged with going to that agency that violated the open meeting provision and say, here's what you have to do going forward. And then if there's further violation by that same policy body or passive meeting body, then a new complaint is filed with the task force. Perhaps then the Compliance Amendments Committee would be brought in. But have there been further meetings since the violation?
I called Eileen Shields, and she couldn't tell me.
You don't know if there have been further meetings?
She wouldn't tell me. I called her. I didn't email her, out of fairness to her. She said she would get back to me, and she hasn't. So, to me, I understand the reasoning process. However, I don't think it's an educational issue. The reason I say that is I think these people are well educated.
Okay, refresh my memory, please. What was the body here that was involved?
It was the DPH Privacy Board.
DPH Privacy Board, right? And I think we found that was a passive meeting body. Okay. Presumably, they would have, if they had a meeting, they would have posted it somewhere.
Presumably, but I asked Eileen Shields for the.
Okay, but they would have, posted it online somewhere. Have you looked on the website on the DPH website, the Privacy Board website? Have you looked at their meeting schedule?
No, there is no meeting schedule because it's the Privacy Board. They don't advertise their.
They haven't been treating their meetings as passive meeting bodies, so there is no evidence of when they meet.
Okay.
That says it. So, they're still private, so that's all I can say. But anyway, however you guys want to work it out, I just wanted to get it worked out.
And if you can't make the Education Outreach and Training Committee meeting this month, you could ask through the administrator, Mr. Rustum, to the chair of the EOT to continue the matter for another month to a date when.
Please. And then that'll give me enough time to sort of look into the website and see if it's been posted or any other thing.
All right. Mr. Rustum, I'm assuming you got that request.
Great.
All right. Thank you, Mr. Banks.
Thank you.
So I don't see there's anything else that we can do on this issue. It sounds like documents have been produced. Unfortunately, Mr. Banks had to file a complaint to get them, and hopefully in your next series of interactions, they will be providing you with assistance.
Well, just a observation. I think they should have sent that stuff back in October. I think it would have
Yes.
saved a lot of excess verbosity and hard feelings. I hope doing this request that they're a little bit more cooperative. Thank you.
We hope that as well. Is there public comment on this item?
Not sure where this belongs, but I'm sorry. My name is Angela Chan. I'm at the Asian Law Caucus. I think
we'll
you called
address
this
yours.
in.
I saw you come in.
Okay, thank you.
Any public comment on the Melvin Banks issue? Seeing none, this item is closed. And thank you for appearing, Mr. Banks. As a point of order, Ms. Chan, we already heard your item, and we've decided that the issue should be referred back to the full task force, for the full task force to consider referring this issue to the Ethics Commission for a finding of willful failure to appear, willful failure to provide written justification, willful failure to comply with the order of determination to appear at the Compliance and Amendments Committee. So that will be heard at the next full task force on the referral to the Ethics Commission for any further proceedings. Thank you. Next item, please. All right.
Thank you. Just for the record, I haven't received anything from the mayor's office at all.
We figured that. Thank you.
Thank you.
Item number 5 is hearing on the status of the January 5th, 2010 order of determination of anonymous tenants against the Planning Department.
Thank you. Anonymous tenants, you have 5 minutes to discuss the status.
Good afternoon, members. Anonymous tenants here. The Planning Department, they did not provide any documents or any photos like we requested, and they are willfully disrespecting this commission and the Sunshine Ordinance Task Force Commission, and they are intentionally violating the law, to say the least. So I wish that, with all due respect, you send this to Ethics Commission for further action. Thank you.
Thank you. Is someone here from the Planning Department?
Good evening. My name is Brian Smith. I'm the Senior IT and Operations Manager for the Planning Department, and just wanted to review some of the history of this records request. Excuse me. And just let you know that there was a record request made to us on 10/20/09 from North Point tenants for docket address 2642-2644. Hyde Street, case number 2009.0642. It was there for 2 weeks, and the tenants did not come to review the case. All the case material was in the case box, and I have a copy of that record right here. We also had some emails going back and forth with the tenants in regard to this request. And the request states that it's some photos and 3R reports in this case report. And for the Planning Department, we have something called a Notice of Planning Department Requirements. And the information that they're requesting is basically it's a template form that says if you have any photos or 3R reports, to please label them when submitting your information. This case report had no photos or 3R reports. That's why they were not in the box, because they didn't exist. So with emails going back and forth with the tenants requested items number 1 and 2, which what I've just talked about, and we told them that the information that we have ready for you is a complete case docket, and we found no items that relate to these 2 submitted requests. And you're encouraged to come here and please review the material. It is available for you at 1650 Mission Street, Suite 400. Again, they email again saying that they want items number 1 and 2. And the final email that I sent back to them was just tenants, the case material is complete and available for review at 1650 Mission Street 400. And that was kind of the 3rd or 4th time that we let them know that it was there and ready for their review. And that's where we left it.
Thank you. We may have questions.
Sure.
Anyone here to present facts and evidence on behalf of the respondent? Anyone else? Seeing none, matters with the task force or with the commission, committee?
Seems to me that they've provided what they had. I'm missing something.
Member Nee.
Yes, with the complainant approach, please. Okay. First of all, you just heard the respondent's version of events, and it sounds to me like, you know, from what he told you, from what he told us, from what Mr. Smith told us, they made every effort to provide you with what you wanted. I guess the bottom line question here really is, what of all the things that you requested, what's missing? Okay.
First, I'd like to address Mr. Smith's response. What he's presented to you, we've never seen what he's presented to you.
Okay, well, you'll be able to present that, sir. You'll be able to present that during a rebuttal.
Oh, okay,
all right.
great.
What we want to know on this committee is, what of all the things you've requested, what has not been provided?
Okay, in your packet you would have Exhibit A and Exhibit B, and this is from Senior Planner Jonas. He's requesting from the architect 11 by 17 PDF version of the plans. That we did not see. This was 9/16/09. The hearing was for the 25th, 9/25/09. So he's talking about the 10th month, which is past 9. So that doesn't make any sense to me. We didn't get a copy of these plans that Mr. Jonas asked for. And the next page on Exhibit B, he requested photos. We didn't get copies of the photos. They're supposed to have photos in the files for when it goes to the Planning Commission on the 25th. And we were never presented those photos. And according to the other document you have in your file, the Notice of Planning Department Requirements number 2, they cannot proceed, they will not proceed unless they have these documents in their file to go to the Planning Commission. And we need those documents to launch an appeal when and if they do issue, the building department issues a permit, we can launch an appeal and review those documents. We don't have those documents to see what it's all about.
What specific documents? Don't just say those documents.
The 11 by 17 PDF plans on Exhibit A, and the photos that are supposed to be attached with it on Exhibit B.
So those two documents,
Yeah,
what you mean, those are the ones that you want?
Those are the ones we want.
You
and,
believe- okay.
and any of the documents that the senior planner Jonas asked architect Middlestat, he said if he had anything else to file it with him. So I don't know. We don't know if they filed anything at that time at all, because they never notified us. Thank you. Is that all?
Member Nee? Member Nee may have more questions.
Okay.
No, I'm good. Thank you.
Thank you.
A question for Mr. Smith? You had stated that there were no photos in the file, is that correct?
For the facts of the case, it says here that on October 21st, the planning department has not fully responded, and it talks to a Robert Middlestat submitted to Planning Commission to the label photos and the 3R reports and similar documents with project address. So again, from my planner Jonas, there was no submittal of any photos or 3R report.
Okay,
and again,
so no
that's
photos.
boilerplate template information that's submitted into our notice of planning requirements.
So the short answer would be there was no photos.
Correct.
To provide to him, okay. What about this PDF, the 11 by 17 PDF of the plans? Do you have
Again, all plans would be in the case document for their review that was left at the planning department counter for their review to come in and see it.
Okay, thank you.
Right, and just so I can, the request here was that we want these documents, you provided all the documents in the planning file or in the box.
Correct.
All right, so, and the plans themselves would have been there, maybe not 11 by 17, but some reproduction of the plans would have been there.
Correct.
All right, so there may be an 11 by 17 copy of the plans somewhere in the planning departments, but it doesn't look like that was specifically, that wouldn't necessarily be needed to have been produced for this request.
Correct.
Sounds like there would be another request
Yes.
needed to get to those. And just to confirm, there are no photos on this project in the planning department's possession. Is that correct?
There are no, to this number 2, the label photos, yes. No, there are not.
Are there any other photos?
I don't have that knowledge. I'm not the planner of record for this case, so again, I'm just the IT manager and operations manager overseeing record requests.
So there could be other photos that
Absolutely.
aren't label photos?
Yes.
Okay. Wouldn't that be similar non-planned documents? If there were other photos? Wouldn't that fall under this request?
And similar non-planned documents?
Right.
Well, that would be an array of other documents.
Right. But that means basically give me all the documents on this project.
Right, which we did.
Okay. But now so I guess my question is, are there not photos then for this project?
There could be photos, yes. Not.
And why wouldn't those have been produced?
They were definitely, if there were photos, they were produced, and they were in the case docket for review.
Okay, all right, thank you. So if there had been any kind of photo, it would have been in the box for the review. And so
Yes.
the fact that there aren't any photos in the box for the review means, at least as the time that box was prepared, there were no photos. Is that accurate?
Yeah, I guess that is accurate.
Okay. Would it be possible that photos would have been submitted after that copy for the box was prepared?
To my understanding, no.
Okay. All right. So as far as we can tell, there are no photos.
Yes.
All right. Thank you. Thank you. Members? What we'll do now is proceeding to our procedures. We provide rebuttal, and then we'll have public comment. So, Mr. Smith, if you have anything else you would like to say in rebuttal, you may do so. Seeing none, the complainant, you have 3 minutes in rebuttal.
Anonymous tenants here. Good evening, members. Every case we've had with the planning department, with the building department, the personnel come up here and they say what you want to hear, and they fabricate what they say, what the truth is, and they win by that fabrication. We sat here, all of us sat here, and hear Mr. Smith. He said there are no photos. Then they said there are photos. Then he said, well, he thought about it. Then he goes, oh, they want to hear there's no photos. So there's no photos. There are no photos. But there clearly are photos. I mean, there are photos in the file. We saw photos in the files. We did not see the new photos in the files. We went there just before the 925 hearing and looked at the file, and these documents should be in the file before they proceed for the hearing, the planning commission hearing, and they did not provide those documents to us. Either Senior Planner Jones had them in his hand. He said he would make 16 copies of these documents, so he's got to distribute them to everyone. So someone has those documents that we should have a copy of, the 11 by 17 plans, PDF version, and the photos, and any other document that Mr. Mendelstadt might present to them for the case. Like I said, Mr. Smith will say what he thinks that you want to hear, just so you'll vote in his favor. But the fact is that we have not seen these documents, and we need them for an appeal. And thank you.
Thank you. Is there public comment on this item?
Good afternoon. My name is Ellen San. I haven't went to the planning for these documents with the tenants. I don't know how many times. I think at least 3 or 4 times. And those documents they now produce was not produced. And just before the hearing, with my experience with them, I know that they have something hiding, withholding. So we particularly went there asking for document. Those documents not there. Even the email was not produced. only after the hearing that there was produced, then we filed the small documents. So that immediately we ask them those, how can we disappear and telling us, at least your assistant, they give a box or something and says, oh, that's all it is. We checked it. We spent hours checking it. That wasn't there. Okay. The 3R report, the photos, this is a standard for every project. Go through the planning, go to the appeal, have to have those things. And they says if they don't provide with 30 days, the permit will be canceled. It didn't cancel. That means there. And the commissioner obviously need those plans. The plan, that was the commissioner's hearing. So the plan should be there. We're asking before, we're asking after the hearing. Those plans are there. I hope that you have to protect the public's right for documents, public records, and cannot just, they don't show up the first time, and then now you have the determination, and then they come up and tell you whatever you're asking, they guessing what you like to hear, then they change the answer. And I think that's not ethical. I think this is a violation of law, not provide a document. Before and after, we have to be in planning department, spend an hour of time and effort to get the documents. And I hope that you do your job. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Members? Member Nee.
This is a very difficult one. What I think would have been helpful to us would have been to be provided a copy of the procedural flow on matters of this kind. What the regulations are, what the requirements are. The complainant says that these kinds of photos must be produced in order for any project to go forward, and now there is some question as to whether the photos exist. Maybe they're not in the planning department's possession, but I thought I heard Mr. Smith say it is possible that there are photos, and he said if they were produced, they would have been in the case docket for review. But maybe they're not in the possession of the planning department, but maybe they exist somewhere, and. Something in my gut tells me that we should continue this and ask that the planning department give this committee provide this committee with copies of how these matters proceed. What are the procedures that are followed? What information must the planning department receive in order to let a project go forward, or to reject a project, to say, no, you can't do this?
I'd second that. To continue it, and what was the word you used, Mr. Craven? All the non-planned documents with the project.
Right, but I appreciate that, and to me the real issue is that someone from the department should have responded in writing before the hearing and then shown up at the full hearing and been able to say at the full hearing, here's what we have, here's what we don't have. Instead, because there's no evidence, it has to come to this body on an order of determination. That to me is really the issue. The planning department may have rules. Their rules may say, and we've held other departments to the same standard, you must track these permits at Park and Rec. You must submit these documents for a project to go forward. The fact that a department doesn't do that is not within our jurisdiction. What we've had is Mr. Smith here say that he doesn't believe there are any photos because if there were photos, they would have been in that box, and they weren't. But then he did say it's possible that there's photos. That to me causes me the concern, right? Are there or are there not photos? It should be pretty easy to, I hope, easy is probably the wrong word given the state of record keeping in the city. I want to know if there are photos. Mr. Smith, can you answer definitively whether or not there's photos? Because to me, that would fall into similar non-planned documents. So, I mean, that's the issue.
Right, so I think the confusion here is the time between when they came to see the document box,
Right.
the case box prior to this, and then some sort of hearing on it that supposedly there were some documents at that hearing that supposedly the guy brought and that planning should have had. So when I talk about...
But I understand that. But my point is, as of the request was made October 21st, 2009, you provided a response by gathering the documents for their review, correct?
Correct.
Okay. As of that date, all documents in your possession related to that project should have been provided. If other documents were handed out at the hearing past that date, they can make a new request for all new documents, all documents that were circulated at the hearing, all documents that were filed after the date we went to review them. So let me be clear. Were there any photos in the department's possession as of the response to the October 21st, 2009 request?
Prior to that response, I'm sure there were, but they had already seen those photos. I mean, are there photos in the case docket? I'm sure there are, but they're talking about a new set of photos.
What set of photos?
At that hearing.
A
new set, right. From what I'm gathering. So what I'm saying is, are there photos in that case? Yes, there are. Have they seen those photos? Yes, they have. Are there any new photos? No, there are not.
Okay, so let me just say that any photos that existed as of the date of this request, as of the date of the initial request, they were provided by the building planning department?
Correct.
Okay, so...
And again, they were provided as a full case docket and set aside for them to come in and review, and they never came in to review them.
And were there not photos in that set of documents? That may be the part you can't answer.
I can't answer that because I didn't go through the case. I haven't myself gone through it. Could there have been photos that they've already seen? Yes. Were there new photos that they have not seen? No.
Were there new photos they have not seen? No. What do you mean by that? I'm sorry. You lost me on that one. The answer is there may or there may not have been photos in the department's possession at the time the request was fulfilled.
Right,
I don't know the answer to that.
Well, but I go back to the point that I'm sure there are photos in the case docket, but they've seen those photos. And the photos were there.
How do you know that? I'm sorry. How do you know that? Here's my question. I'm sorry. Okay. As of October 21st, 2009, I get a request. I'm the department. I gather the documents. I put them in a box. That's what we're here on today. That's the only thing we can deal with. If there are new documents, those are subject to a new request. So I just want to really focus on as of that date. Okay? They say that as of that date, there should have been photos, and there weren't. And I will double check with the tenants and make sure that's exactly what they're saying, but I believe that's what they're saying. As of that date, were there photos in the file, in the department's possession that were produced?
All I can say is that everything was in the case docket for their review. Everything that the planning department had.
You don't know if there were photos?
I don't personally know for sure whether there were photos or not.
All right.
I just know that everything that we had was in the case for them to review.
All right.
As of that date. And they did not come to review it.
All right.
I think that's the most important thing here. They never came to review the case docket as of that date. And again, I have the copy of the
form.
Of the form, the record request that shows that it was there, ready, it's stamped here from planning, and that they never came to review it.
All right. Thank you.
I have a question.
Yes, Member Johnson.
Mr. Smith.
Mr. Smith.
Mr. Smith, I have a question for Mr. Smith. How do you keep track of the records of when new photos or photos may be in at one time, or if there are new photos taken? How does your department keep track of when photos are taken?
Well, it's all part of a case docket. So if photos are submitted, then the planner is in charge of that material. When there's a record request, the record request is made to the planner, and then the planner puts the case information into that docket, into that box for review, which was done by Jonas Ionin as the planner of record.
All right, thank you. I have a follow-up question for the tenants who are dying to answer something anyway. Did you go and look at the response for this
We've always
request?
gone to see whenever we requested it into like review documents. We've always gone. I don't know what he's talking about.
All right, but narrow question, sir. Did you go and see the response to this request?
To our request, yes. I don't know what he's talking about. The documents that he has on file. I don't know. When we requested documents, we've always went to go see him all the time, every single time.
You made a request on October 21st as the anonymous tenants, and you went to go see that request?
Yes.
Yeah.
If
And the
I
document
made a
that Mr.
request,
Smith-
we went to see
Thank
it.
you.
Yes.
The document that Mr. Smith provided
Can
me
we
said-
continue this so we can see if there are photos in the file?
Sir, you'll have your chance. Please don't interrupt. The document that Mr. Smith provided to me didn't have anonymous tenants on it. It had Ms. Thang's name on it, I believe. So I don't know if that's the same request or not. So I'm not really sure what to make of that point. I come back to this issue of we have to rely on the department to say we responded. And unless there is proof that there are photos that existed within the planning department sit down, if someone asks you a question, they will ask for you to approach. If someone has evidence that there's a photo that wasn't before there for them to look at when they went into the response, they need to prove it to us, and we have no proof of that. We don't have any proof here of there were photos or there weren't photos. We've really a lack of proof on both sides on this issue. And so I'm of the mind not to take any action on this. There's nothing else I feel like I can do. The parties had the opportunity to come and say, here's what I didn't have. Here's what they had for me when I went to look, and here's what wasn't there. And I know there are photos because of X, Y, and Z. We have the department saying they provided everything. So, Memorny.
Yeah,
You have an email saying, send me the photos. You do not have an email saying, here they are. Okay? A lot of times people request things and projects, they don't get submitted. Memorny.
I tend to agree with Member Craven's assessment on this. There's really, at this point, there really is no further action we can take. If the complainant discovers later on new evidence that he wishes to bring to the task force and request that the case be reopened, he's welcome to do that. But at this juncture, it looks to me like there's really nothing further that this committee or the task force can do.
Right, and if the complainant wants to make a new request for all documents currently in the possession with regard to that property, there may be, documents that have been submitted since October. I don't know, but I don't think there's anything else that we can do on this matter. So I would move that we find no further action and move to the next item.
Second.
Without objection. Public comment, next item.
Next item is item number 11, which is public comment on items not listed on the agenda.
This is public comment for items not listed on this agenda. Anyone have public comment? Seeing none, public comment is closed. Thank you.
Item number 6 is the hearing on the status of the January 5, 2010 order of determination of Ellen Sang against the Department of Building Inspection.
Ms. Sang, you have 5 minutes.
Good evening. Thank you for your order. Planning Department and Ms. Straw did provide a document yesterday. I hope they send the message when the public requests the public record, the building department, Ms. Straw, will comply with the law and provide it within time limits allowed by law. We don't have to, any public record we request that we have to come to you and file the complaint in order to get them. And thank you for your effort, and thank you for building department comply with the order.
Thank you. Is there a representative from DBI? Thank you. You have 5 minutes.
William Strawn, the Communications Manager for the Department of Building Inspection. Yes, that PDF, as the order of determination required, was sent to both the task force and to Ms. Sang on February 2nd. And I did bring, possibly the Compliance Committee would be interested in seeing that our commission in the current budget has presented an ongoing plan, as I explained to the task force in January when this item was under discussion, that we have a multi-year program to do the scanning and digitization that is required. And I'll repeat again, this specific document that Ms. Sang requested was with the vendor that's doing the scanning. The vendor is 6 months behind relative to when the documents are submitted. That meant in order to comply with the order of determination, we had to have them go and retrieve the document and then make the PDF, which we have now done. But I just want you to understand again that a document from November was not yet delivered back, and it was not in the computer system ready for an immediate availability as the complainant has been alleging. It's not in my interest, it's not in the department's interest to withhold documents. We're very happy to provide them. We did offer this, as I made clear in January, in a hard copy form, and Ms. Sang made it very clear she did not want it in that form. So the order of determination said we had to provide it as a PDF. That has now been done. And as I said, if you would like this budgetary document, which was just approved unanimously by the Building Inspection Commission, it's on page 7 and 8 of that document. Thank you.
Thank you. Is there anyone here to present facts and evidence in support of either the complainant or the department? I forgot to ask about that. Seeing none, the matters with the task force. Member Nee.
It sounds to me like there's been compliance. No further action required other than the rest of the procedural aspect of this matter. But I don't think that any further action on part of this committee or the task force is required. Thank both sides for working together on this and seeing it to a successful conclusion.
Further comment? Seeing none, Mr. Strawn, you have 3 minutes to rebut if you wish. Ms. Sang, you have 3 minutes to provide a rebuttal if you wish. Please use the microphone.
Mrs. Straw still have some misstatement I would like to point out, because the document he says that he would like provided to me is for different documents, and the date is totally different. So they cannot mix up. Oh, he has the tendency to mix up the issues or the documents before you and get so confused. And I think that he should be honest. When we're talking about one document, we address that document. And we're talking about something else, and we're talking about something else, so that we can concentrate to get the matter resolved. And thank you for your time.
Thank you. Is there public comment on this item? Seeing no public comment is closed. No further action is necessary, and the matter will be concluded. Thank you both very much. And we hope not to see you again. Hopefully all the records requests are complied with. That can at least be our hope. Next item.
Item number 7 is hearing on the status of the January 5th, 2010 order of determination of Mike Adario against the Arts Commission.
Thank you. Administrator?
Madam Chair, I received Mr. Adario left a message on the answering machine saying that he had an emergency, medical emergency, that he needed to attend to and would not be able to be present at this meeting.
I think you mean Mr. Lazar?
Sorry, Mr. Lazar. Yes.
Mr. Lazar.
My apologies.
Because I'm Mike Adario.
All right, I appreciate that. But Mr. Dario, seeing as you're here, why don't you proceed? You have 5 minutes.
Well, I'm kind of disappointed that no one had told me about that earlier, that Mr. Lazar would not be here. I'm Mike Adario. I'm a member of the San Francisco Street Arts Program, and I'm also the chair of the San Francisco Street Arts Program Liaison Committee. I don't know if you need a little background on the program. I'll try to keep it short. The program is a city program that allows artists to sell their work out on the street. Although it is a city program, it receives no money from the city. It is totally self-funded by the members' licensing fees. That said, we have had a lot of problems within the office of incorrect licensing, expiration dates, transposed numbers, license issued out of sequence, 900 license numbers skipped. And last year we found that $400 was stolen out of the office, and staff concealed that for 17 months. When that was brought in front of the commissioners, and this was during the last budget meeting, they requested a financial audit be done by the controller's office. Mr. Lazar delayed requesting that audit for 5 months until the controller already had his priorities set for that year, and the audit was never done. So that's a little bit of the background of this. I asked Mr. Lazar for an IDR request, what our fund and what our program ended up with at the end of the fiscal year, and he came back with an email that says, while the surplus is shown of $10,112, our understanding from the controller is that the surplus has been absorbed in covering the program's deficit from previous years, leaving a negative balance of minus $2,210.63 to carry forward into FY 2009-10. I asked him to give me the paperwork on that, and he said, well, it was a calculation. And I asked him for the contact person at the controllers, and he just ignored my request. I spoke to the controller. I sent him what Mr. Lazar had sent me, and he stated that he could not find the shortfall. And he found additional money that should have been in our account, $30,000. So this was going on behind the scenes. We didn't really hear about this until later. But that seems to be par for the course with that. There's a lot of evasion and deception. We do get some records, or we get dumped with records where stuff that I haven't asked for. And this latest thing that the program is trying to do is they don't admit that there's $30,000 to $40,000 in a surplus. They say there's a deficit, and they're trying to, or they have so far, voted on an increase on our budget, saying that every public record request has to go to the city attorney, and the city attorney is charging us accordingly. And they said that my record request amounted to 65 hours at $214 an hour. And that's the way that they're saying they're going to comply so they don't violate the Sunshine Ordinance in the future. So it's kind of like the circular logic where if I ask for more, they're going to charge me more, and or they're charged the programs. Here's the sheet where the budget that they submitted and was voted on. And at the time, they didn't tell us that there were $30,000 to $40,000 in surplus. So we still have an issue with that. We've been trying to rectify. As you can see on the lower left-hand corner there, they count out that how many city attorney hours they figure are going to be requested. And they also publicized this with the members, saying you're going to have to pay more because Mr. Addario is asking for this information. So they tried to, an attempt to disparage and vilify me for asking for these requests within the membership. They don't go back to the original why it was asked for originally. So I don't know. It seems like they have not a lot of.
You can wrap up.
It seems like they really don't respect the Sunshine Ordinance and in its spirit. And whatever you can do to bring that forward to them, I'd appreciate it. Thank you.
Thank you. Is there anyone here to present facts and evidence on behalf of the complainant? Seeing none. Is there anyone here to respond on behalf of the Arts Commission? Present facts and evidence in support of the Art Commission? Seeing none, the matters with the task force. Member Nee.
I am. Mr. Dario, let's focus very narrowly on what you requested. The task force found that the Arts Commission was to appear here. We ordered that the task force ordered that the commission appear here to tell us if all requested documents had been provided and redactions, if any, were listed and justified. So I guess our bottom line question here is, of the request that you made in this particular case, regardless of your experiences in other episodes and so forth, just narrowing down to this episode that's before us right now, of the things that you requested, what has not been provided, and what if any redactions have been made on things that were provided, and if there were redactions, were those listed and justified?
It wasn't actually on the redaction issue. It was a modification of a time slip. That was my concern. There was time sheets, and somebody had whited it out and written over it. They claim that that's just something that happened. I have no way of telling if they're telling the truth on that. As far as the paperwork, I received the paperwork that I requested. I actually received more than I requested, some things I didn't need, but that seems to be something that they do to bog down.
All right, so everything you requested on September 23rd and September 29th has been provided finally?
I believe so, yeah, everything.
Okay.
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 Well, I think there is general agreement that the practice of that you describe, which is commonly known, I think, as sandbagging, is really not a good thing. But I guess the question there is, was the sandbagging to an extent that it really prevented you from getting the information you wanted to see?
Well, I think what their strategy is to sandbag me, to throw everything through the city attorney, and to say, well, you're costing us so much money because you're asking for so much, and come back and say, and tell this to the members.
Okay,
so
but
it gives a chilling effect.
In this case, did the surplus of information that they provided prevent you from getting at the information you were really looking for?
It slowed me down.
Slowed you down,
Yeah.
but it didn't really prevent you?
No.
Okay, thanks.
And just as a curiosity, how many requests have you made?
Well, I think there's been about 10. But what happens is I don't usually get what I normally need. I have asked for the balance statements, and apparently there's no balance statements because the city goes through the famous system, which is yes. So I'm in the process of learning of what to ask for as we go back, and they haven't really been that assisting to me.
Right.
So.
Yeah, there was a provision in the ordinance that they're supposed to, if you say, hey, I'm looking for this type of information, they're supposed to respond to you and say, here's the type of information we collect and here's where it's kept.
Right.
So they are required to do that. How many pages of documents have they turned over in total to date?
I think the last one was
Altogether, of all your requests? I'm just curious.
400.
400 pages of documents?
Yeah.
Okay. I mean,
But some of those were emails that I had sent them.
Right.
That they sent me.
Right. I appreciate that. I agree with Member Nee. It doesn't seem like there's anything left for us to do on this particular order of termination, though I have to say I am somewhat troubled by the Arts Commission charging the street artist program fees for responding to public record requests and putting that in the budget of the street artist program, which is paid for by the street artists.
Well, I'm running it through the city attorney's office.
Well, sometimes you're going to need to run. It's hard for me to discuss that without Mr. Lazario here, because sometimes you're going to need to run things by the city attorney's office. There are a lot of privilege grounds and things that, possibly have to be reviewed. But the ordinance provides that responding to public records requests is the duty of every city and county employee. And those are normally costs that are borne, by the city and paid for and supported by our tax dollars. Because of the particular nature, I don't know if it's peculiar or unique, but because of the particular nature of how the Street Artists Program Committee is funded, i.e. self-funded, I gather, from your licenses and those sorts of things. I mean, it does seem to me to set up this kind of retributive scenario that causes me a lot of concern. I'm not necessarily of the view that that's within this order of determination, but it may be within the purview of the chair of this committee to ask at a next education outreach and training committee for the Arts Commission to come and provide a justification to the EOT body, which is the body that kind of works with departments to make sure that they're going forward complying with Sunshine Law, to explain to them why or what the justification is for charging this money to the underlying program, increasing licensing fees on these artists because of their duty to comply with the Sunshine Ordinance. And so I will make that request through the chair of the task force, who has the ability to refer issues to various committees, but it does trouble me. Member Nee, you'll have a rebuttal, so. Okay. Member Nee?
Yeah, I tend to agree. As a matter of fact, even though I didn't say so earlier, I do have a concern. I share that concern. And I'd be happy to refer this to EOT.
Member Washburn?
Yeah, I was wondering how widespread this is with other departments, because there are departments that collect fees from various segments of the public.
I haven't heard of it before. Member Johnson?
I was just commending on your referring it to our chair. I think that, as a member of EOT, I would really look forward to taking up this issue.
And through the administrator, if this item is scheduled for EOT, Mr. Dario, of course, should be notified of that if he wishes to attend. Is there general public comment on this item? Seeing none, Mr. Dario, actually, you have 3 minutes to provide any other comments you would like.
I was just curious about, is that training that you're talking about? Or would it go to a committee first and then they would have some training? I seem to think that they don't respect the Sunshine Ordinance and there has to be some training. It's always like I have to reinvent the wheel. They tend to like to keep things secret, and we find out about them. I mean, the money being stolen and not telling us is an egregious example of something that should have been brought forth to the members, since it was the members' money. And we didn't even know about that to ask about it until a rumor came around and we asked about it. So I think there's definitely a need of training, and I appreciate you seeing that. Thank you.
Thank you. All right, this matter will be, no further action will be taken at this committee, but it looks like EOT may deal with some ancillary issues in the future. All right, next item, please, Chris.
The next item is the developing recommendations for the proposed electronic document retention policy.
Thank you. I see we have a representative from the Committee on Information Technology here. If you could introduce yourself for the record.
Yes, Richard Robinson, Chief Operations Officer for the Department of Technology. Can I answer any questions?
Yes, thank you for attending, Mr. Robinson. Basically, I think the members, as you can see by some of the prior complaints, the issue of retention of email and production of email and searching of email, restoring of email have been issues that we've had complaints on almost every month for the past year and a half, at least. So it's an issue that we're seeing repeatedly and is taking up a lot of the city's time and the task force's time in trying to figure out what is a just and equitable resolution to some of these issues. So I know that last time there was a representative here, they were telling us about the exchange, the transfer to the Microsoft Exchange server platform, and also about various initiatives. I think there was a request for production, perhaps, a request for submittals to help departments work with COIT to develop a way of addressing these issues of what we need to do in terms of ensuring built-in for retention and production and search and capacity. So if you could just give us, an update, we would really appreciate it.
Sure. Well, I'll go back a little bit to give you a little bit of a history. So I think a little over a year ago, the Committee on Information Technology worked through its process to make a recommendation that the city move off of its existing email platform and actually move to a unified platform. The agreement was that the city would look to move towards a hosted and unified Microsoft Exchange platform. But doing that was going to cost a fairly significant amount of money to do the migration, as well as take a little bit of time to work out. The committee then put a budget together to do that. The budget, when it went through the budget process last year, was cut back significantly. I think they had estimated approximately $4 million. What was left at the end of the day was close to $800,000, which was not enough to actually move the project forward. However, there were some key components of things that needed to be done prior to making that move anyways. So a determination that was made with the monies that were left, about $800,000, that the Department of Technology, through the direction of COIT, would move on three paths. One was to do a technical piece, which is called Active Directory. So in the event that the city got to the point where there was funding to move to a unified hosted Exchange environment, there was some technical infrastructure that needed to be designed and put into place. The Department of Technology is in the process of completing that. We've actually worked with Microsoft to come up with what they call an Active Directory, put out a bid to procure the equipment to put that in, and we'll be implementing that infrastructural piece over the next several months. There were two more components. One was to put out a request for quote to have someone come in and actually do the requirements vetting process. And then lastly, there was to do a pilot with a department organization to kind of vet out some of the technical issues. To me, the key piece of this was that request for quote to build a proposal. So the Department of Technology put that out, and as of a few weeks ago, indicated an award, an intent to award an organization to come in and do that. Part of that work was to have the organization that comes in meet with all of the individual departments to truly come up with their business requirements for email retention as well as accessibility. We wanted an objective department that could listen to the department, but then also vet any public policy, any government law issues that might be part of that. So if it's health services or law enforcement or public safety, above and beyond what they want, what does the law require, and then aggregate that so when we build a unified solution, we're taking into consideration. Also, we wanted to take a deep look into open and transparent government and look at if there's a way that we can architect a solution that doesn't put a huge encumbrance on the department to always go do email investigations and pull this information? Is there a way that we can design a system that if people want to see what emails are out there, that there is a vehicle and a mechanism that they can do that without having to invoke this process? One that also takes into consideration, certain emails may be confidential, some of them may be protected by HIPAA, some of them may be public safety issues, and if we can take a look at that and also vet that against public policy. Like I said, we have indicated an intent to award this to an organization called Citrus at UC Berkeley, which is the Center for Information Technology Research for the Interest of Society, which is a group of people. It also is the Samuelson School of Law and the iSchool. So what we really wanted to take was a holistic view, not only from a computer science, electrical engineering, IT infrastructure, but also from a public policy and law view. So we're in the process of finishing the contracting process and having them come in and do that work, as well as we've identified a law enforcement agency to do an initial pilot where this organization can also vet some of their security and public policy issues as they implement this first trial phase. That was the short version.
That's great. So the request for quote, does that have the request for a quote that you have sent out indicating your intent to award it to Citrus, does that have kind of the parameters about what Citrus is going to be doing? What are some of the components of how they're looking at it? What's in that? Is that something that would, that you could release to us, for example?
It does. There is a statement of work, and we're in the process of finalizing that contract and doing some negotiations, getting the cost appropriate to what we're at. So when we're finished with that, my hope is sooner than later we can give you a copy of what that is. So there will be a statement of work. There's several phases to that. There's a technical piece, there's a requirements phase to meet with the departments, then there's a vetting piece of this against public policy and government law, and then there's the pilot component to that. So they will be doing all of those. We just need to finalize the contract with them in UC Regents.
Right. Was there a public document that was issued before this, or is this really the only document that's out there?
Yeah, there was a request for proposal that was put out through the city stores as well as to other agencies to respond to.
Okay, great.
So actually theirs was the most complete of all of the proposals that we received.
Great. So when the quote is finalized, when it's finalized by Citrus, if you could circulate that to our administrator and he can send it around to members who are interested, that would be great. Is there consideration in that for meeting with perhaps the task force or our city attorney who's assigned to the task force, or some members of us as well, to see if we could play a role in that process?
Absolutely. Like I said, we wanted this to be as open and complete as possible. We really want to take into consideration everything that we possibly can. And part of that statement work was to meet with all city departments. From the Department of Technology standpoint, our staffing levels are getting lower and lower. These requests for these email sunshine requests and that are going up and up. And we're really at a critical juncture. I mean, we're at that moment of elasticity. We can't maintain this stuff. We have to look at things differently. So that's one of the things that we want to make sure that we look at this, in kind of a new light. How do we make it easier for citizens to get to these records from a technical standpoint, as well as make sure we protect the things that we need to protect.
Member Washburn?
I also wanted to suggest, in addition to members of the task force, that there are members of the public who are very knowledgeable about these matters too. We might want to include them as well in a public vetting sort of.
Certainly, and I'm sure they'll be interested in seeing the quote when it comes through as well. Some of those members have, I'm sure, made many requests to the Department of Technology, and their names are probably well known within the Department of Technology.
Well, and I want to be, clear. That's why we like the organization that's coming in and doing that, because outside of the this is what people want. I mean, there's some fiscal considerations that have to be taken into consideration, and we have to be very upfront about that. I mean, we can't retain everything forever. There's a significant cost to that. But what we want to do is meet with the departments, have them meet objectively, and clearly define what are their business and functional and technical requirements, and how does that contrast to what is the law, what are the ordinances, because we're really going to have to be clear when we build this and define it, what it is and what it isn't, and what we can afford and what we cannot afford.
And what you're required to afford under the law.
Exactly.
Yeah. Okay. Any other questions? Well, that's been very helpful, because we were wondering what the status was since we last saw you. So, and just wanted to make sure that the process was moving forward. It sounds like it is. And we look forward to working with the folks from Citrus in any capacity that we can to be helpful on this. Certainly, we may represent one view. Everything should be open except for the small percentage of information. But I think most of us are cognizant of the technological and fiscal issues as well. So hopefully, we'll be able to be part of that process as it moves forward. So we certainly appreciate your attendance.
Okay, thank you.
And if there's anything that we can do to facilitate it, or any meetings that were particularly helpful for us to attend, please let us know. We're happy to do so.
Absolutely. Okay,
Great.
Thank you.
Thank you very much, Mr. Robinson. Sorry you had to sit through the rest of the meeting. You did. I would take public comment on this item, but there's no one in the public gallery. So this matter is closed. Does the committee feel like we should have this on our agenda for the next meeting, or is this something that we're shifting to our back burner? Member Nee?
I think whether we have this for our next meeting depends really on whether there's going to be anything new by that time. We could schedule it, and then we can discuss it or not as matters fit. I think at some point it might be a good idea to have a special meeting on this topic, though. There are a lot of people who are members of the public who are interested in this. Kimo Crossman and Bruce Wolf, and among others. And I think for us to devote maybe a half day or even a full day to really looking at this thoroughly could be of a tremendous help to us, and invite Mr. Robinson and other members of COIT to update us and give us some idea of what it's technologically and fiscally feasible for us to do within the task force, because as the guidelines that we plan to adopt are going to be first for us, with a hope that other people would kind of use it as a template. So I think there are other matters that are a bit more pressing time-wise, particularly, of course, the ordinance amendments package. I think that needs to be really front and center for us for the next few months. But once that's out of the way, and when time permits, it would really be a good idea for us to tackle this in a very extensive way.
I agree.
Yeah.
I agree.
And I also want to give a big hats off to Member Washburn for the research she's done on this. This is outstanding. Very, very helpful.
Thank you.
Definitely. All right, well, why don't we do this? We'll continue to have this on our agenda for the next meeting. If the quote or the award, the contract for Citrus comes through, we can, if it comes through within the next month, we can have it on our agenda and include it in our packet. And if there are concerns that we have or issues, we can review that and discuss them at our next meeting. But otherwise, I think I agree with Member Nee. We need to make the amendments the focus. All right, so no public comment because there's no one in the audience. The next item?
The next item is the discussion on the proposed amendments to the Sunshine Ordinance.
All right, thank you. The first item I'll note is that Chris has provided us the schedule from the Department of Elections. And if I read this correctly, and there's a substantial chance that I don't, it looks like June 15th, 5 p.m. is the deadline for The notification of ordinances and declarations of policy be submitted by the mayor or 4 or more board members. Is that correct? Do I have the right date there, Chris?
That is what was provided to me by the elections department.
Right. So that to me would mean that you would need to have gotten the packet to board members substantially in advance of that so that they can decide whether to move on it or to provide for additional revisions. Remember, Nee?
Yes, I would say we should aim for early May. And that's not a lot of time. It's, it's 3 months away, which might seem like a long time, but given that all of us have outside activities and that this task force and this committee meet only once a month each, it's really not a lot of time. So what we're going to need to do, I think also that too would be worth at least 2 meetings, special meetings of the committee or the task force, either one, probably the task force, because it's really going to be the full task force that needs to sign off on it. So
That would be late April then.
we should schedule a special meeting in April, after which
Or perhaps the first week in May.
well, I would say
So we
maybe
meet the 4th week.
That seems.
Perhaps it's not. I mean, that's for the full task. But that means we have to get all of our revisions and amendments done by then so that they can get them.
with also, I think, with
They want to make changes. and then-
with a summary of the major change, what the major changes are,
Sure, I mean, that's not going to be too hard.
footnotes, et cetera. We can certainly use the previous footnoted documents that I believe was Member Craven Green prepared as a
They need
basis.
to be edited.
Okay, but we can build on those.
Yeah.
Um,
I mean, I think that we'd have to have, if we could have a meeting in early April, that's fine, but that gives us only one more meeting other than this to go through 3 and 4, assuming that we get through 2 today, which maybe is possible, depending on how many complaints we have next committee meeting. I mean, we can certainly agendize 3 and 4 for the next meeting, but anyway, it's tight. It's a tight time frame.
Well, I think what Member Craven Green suggests is doable. 3 and 4 for the next meeting of this committee, and then
A special meeting in April.
special meeting in April. Maybe the 3rd week in April.
The week before our full meeting?
Correct.
That probably makes sense to shoot for. We'll leave the scheduling up to the chair of the task force.
I'll be right back.
Okay.
Do we want to take a 5-minute recess and then start back with the amendments?
Yeah.
Yes.
Let's do that, because it'll take us some significant time. All right, well, we're in recess. We're back on the record. So we're at the amendments. What Chris has provided is a copy of the ordinance showing, it should show at least, all of the additional amendments or discussions that we've made to date. So what this one will show is with underline will be additions that have already been approved. Single strike-throughs are additions or deletions that have already been approved by the full task force. And then double underlines or double strike-throughs represent the work that we've done since that date. So that was what we decided would be the best way of tracking what has been done. Flipping through here really briefly, I can't really find any double
No, I don't recall seeing any, frankly.
double underlines. Maybe Chris could tell us where an example is.
I just came across one, Madam Chair.
Oh, here, page 37, there's a big chunk.
Oh, yeah.
Oh, see, mine doesn't have that. It doesn't have the double. It has this.
Oh, this is what you don't.
The new one?
The new one.
The
That's
new
what you should be
37.
looking at. Yeah.
I see, okay.
And 49, I think. Page
Right,
49.
so I'm just showing that this is how we're going to be tracking it. So hopefully that will be clear for us and for everyone else who comes after. It's going to be a little difficult right now to figure out where we should start, but I think where I'd suggest starting is on 67.3B1, and we should probably look at the new version that Chris just gave us. Well, first of all, do other people have suggestions that they've looked at this past month?
I've just came up with a bunch of typos, evidenced by these pink slips. But
Okay.
as far as the amendments themselves, I think they're very clear. I was able to follow what was there and what's there now, and I like everything I saw.
So you have some typos?
Yeah,
mostly.
but they're minor.
Right. Well, then, why don't we just do this? Why don't you give Chris or give me the typos, and we can just make those changes as necessary. If there's anything
Okay.
substantive, we can come back and say, hey, that's
No,
substantive.
they're not.
but-
No, it's like,
Right.
For
Right.
example, like city, maybe that should be a capital C.
It should be consistent, basically,
Yeah, so
is what it
that's-
should
There's
be.
one there, that,
Right.
little things like that.
Right.
Just throughout.
Okay.
Here's a space is missing, nothing big, but.
Right. Well, I mean, for example, what I'm going to ask Chris to do is go through the ordinance and make sure that every time open government is mentioned or the task force is mentioned, that's replaced with Sunshine Commission.
Yeah.
And so if this body can just agree to that, then Chris can go and do that on his own, and we won't have to revisit it. That can be done before the next version. And I think for the same thing, we'll have to figure out whether or not we want to have city cap, what the appropriate capitalization is for city. Maybe Member Nee or Member Washburn can tell us. If we talk about a city policy or the city department, or we talk about the city,
Yeah,
employees of the city and county of San Francisco.
Should be capitalized.
Okay, so when we say the city and county of San Francisco, that should be capitalized. What about city policy?
Shall be city policy.
Well, I would say that any time it refers to city government, when it's official, whether it's the city and county of San Francisco or whether it's city policy, I would say in both cases it would be capitalized. I would say if we're talking about, say, city streets, then, streets within the city, that would be different. But if
So
it's,
if we say city employees, then city would be capitalized.
Then
If we
city
say
would be
City
capitalized.
policy, city is capitalized.
That's this city
Yeah,
that's
because-
being referred
as long as
to.
it's a
Right.
government, yeah.
Yeah.
Okay. All right, well,
Official.
Chris and I will make those changes so that we can do that. Does anybody else have suggested changes or comments in general, not to the sections that I've identified, but to other sections? No, well then let's just go through, I guess, the order of the ones that I've suggested. Does that make sense? All right, so the first one is 67.3B1, which is the definition of meeting. And we had we had narrowed the use of jurisdiction to hinge in that subsection of policy body. This is basically more consistent with the Brown Act. And so the one place we did not change that was in B1. It still says any item that is within the subject matter jurisdiction of the city. So I would suggest, I don't see why there shouldn't be why there should be a difference. It should be jurisdiction of the policy body.
Page?
This is page 5 of Chris's new version. And that will be consistent as with 2 and with 4A and with 4B. Does that make sense?
Mm-hmm. It does, yes.
Okay. I'm still not happy with these definitions. I'm not sure if Rick or others have had a really good chance to sit down and figure out the policy body and passive meeting body definitions. We've tinkered with them, and I still don't feel like we have a grasp on what we've done and what we might be doing by implication. Trying to figure out, well, what about the DPH privacy board? Is that still going to qualify as a passive meeting body underneath our revisions? The answer may be no, because we've deleted portions of that definition. So, I still think we really need to go through that. For example, we've deleted on page 7, subdivision 5, notwithstanding the provision of 4, passive meeting bodies shall include a committee that consists solely of city employees when such committee is reviewing, developing, modifying, or creating city policy or procedures related to public health, safety, welfare, or relating to services for the homeless. In 2, we've kind of included groups that meet with residents, but 4 says it does not include a committee that consists solely of city employees that's studying internal department affairs, which is not expected to modify or change city policy. That, is a narrowing of 5. So do we really want to do that? Maybe we do, maybe we don't. And that's really what I don't know if people had thought about that. That's really what I hoped we all had done before this meeting. But I'm not sure anyone really did the heavy lifting on that besides me. And I need people to help me. I can't do it all. Because I don't have the experience of knowing how this is all really developed and how different passive meetings are treated. And I really want us to make a knowledgeable decision on this. Member Johnson.
On page 7, at the under, what is it? 2, any other board, commission, or other body enumerated in the charter, could we say by the charter? That way, if that come up, then we...
Which version are you looking at? I'm sorry?
This one.
Versus.
Okay, I'm sorry. And this is under policy body definition? I'm sorry. Go ahead.
Yes, like line 22 or 21. How we underlined or other body enumerated in the charter. Could we say by the charter? So if something like that came up where it was more malleable, so that we could determine whether or not that they were having a passive body, because we determined that they are a policy body.
Well, it's really determining the policy bodies are bodies that are created in the charter, right? That by charter amendment. If you really could, the charter itself is not going to create the body. It's basically an amendment will say this is a policy body. Basically we put other body in there because, for example, the task force is a charter body, but we're not a board or a commission, or at least we weren't at the time of this drafting. So that's why we put or other body, to make it clear that, just because we're a task force. It basically means anything in the charter, any body in the charter. Member Washburn?
I think what would be helpful is to...
Madam Chair, could you speak through the microphone?
Oh, I'm sorry. In rereading this again, it seems to me we ought to consider flipping the presentation or the definitions of policy body and passive meeting body, because we refer to policy bodies when we're defining passive meeting bodies. So I think we should start out with policy bodies, then define passive meeting bodies.
Right, just as a matter of course. I mean, that makes sense.
Thank you. That might help.
Yeah, I mean, it's just more of an issue of ease of reading. It doesn't really change the substance in any way.
Right, no, but I mean, but it would help understanding if, it doesn't change the substance, but it would further comprehension of what we're doing here.
Okay. Right, I mean, we'll just need to make it clear that we're not, the only issue with doing that is that then it's going to be hard to track what we're really changing from the definitions, because it's all going to look like it's a change. Do you see what I'm saying? This is just as a purely practical matter. If we move it, then we're going to have to underline it all.
Sure.
And then we're going to be like, whoa, what's the new stuff? So my preference right now for at least this process, I think when we're at the full task force, we could say, well, we really want to reorder this. Let's do that. But like for now, I would say let's not do that, because it will really kind of go like, well, whoa, they really are messing with it all. They're changing all the definitions when we're not. We are doing something significant. I just don't want it to minimize from people's ability to see what we're doing.
But you might change the numbering.
Yeah, we could do that. For example, right now we could say,
Right.
Chris, make CD and make
DC.
DC. And that way, when we...
And alert, read
Right.
that. I mean, I don't think anybody there reading this is going to notice that.
Right.
I'm sure they won't, but...
Right.
And when this goes on the ballot, there's going to have to be an explanation.
Right.
I really think it doesn't make sense to be using terms you've not defined yet to define other terms, particularly these critical terms.
Okay. All right. There is, the next one on my list is 67, 3B, 4E.
Madam Chair?
Yes.
On that one, it seems to me that I saw a memo from a number of FOI, some people interested in Sunshine. There may be a problem with this.
I had circulated this language to Bruce Bregman, Terry Frank from Californians Aware, Peter Scheer from the California First Amendment Coalition, Tom Burke, who's an attorney at Davis Wright Tremaine, and Stephen LeBlanc, who's an attorney over in Alameda, asking for their comments on this section. And Terry Frank did have a few questions. He didn't like D because it seemed to go beyond the Brown Act. But D is actually not new. D is actually something that was omitted by the drafters of Prop G. It was in the ordinance originally, and when the drafters of Prop G put together the changes, it was omitted. He also had a question with E, and his point on E was, well, why can't they just hold a joint meeting? Like, why should we allow members of the task force to go in sufficient numbers to create a meeting to the Board of Supervisors? Why can't they just hold a joint meeting? And my response was basically, fat chance. My response back was, I hear your concern, but, as a practical matter, it's not that easy to schedule a joint task force and ethics commission meeting. It's not that easy to schedule a joint task force and planning commission meeting.
Right.
And that if members of this body want to go talk to the planning commission about something that might deal with sunshine or openness, that's on the agenda of that body, publicly noticed on the agenda of that body. And the members aren't saying, here's what we're going to do in the task force, but they are representing their individual views, and they may, there may be other members in the gallery who say, I agree with this member. I mean, there are implications for meetings there, no doubt about it. But I think the benefit of allowing that outweighs the risks. And I asked Terry Frank to respond, and I haven't heard back. So I would leave it in for now. I mean, I think, it's something that we've come up against when we want to go testify at the Rules Committee or the Budget Committee. And, it's like, well, Rick and I can't go because then we'll be the Compliance and Amendments Committee. Now it's a little bit different with more members.
So you want to put in observer publicly?
Right. That's what I want to do
Fine
is
with me. Let's
when
do it.
the majority of the members attend a meeting with another policy body to observe or publicly comment. We want to make it clear that you can't go and sit there and the four of us can't sit there and talk about matters within our jurisdiction. No, we can't do that, but we can talk to the body.
All right, I'm all for it.
Or we can observe without discussing.
Right. Okay.
With D or E now?
That's on E.
E?
Yeah, that's on my suggested revisions. This is E.
Great idea.
I have a question.
Yes.
Under, it's on page 7 at the top, line 1. Advisory, passive body, a passive meeting body shall mean advisory committees created by the initiative of a member of a policy body, or if we replace department head with department other than the mayor, or a department head other than the mayor. So if we replace it with department head with just department, would that, as an example, make the advisory committee of the DPH or the privacy committee a passive meeting body?
I mean, arguably it would, unless it consists solely of city employees, right? Because then these other ones talk about.
So that's contradictory.
It's not contradictory. It's just saying it's different.
It's different.
Right. I mean, you can say that.
But if they were both in there, one the department DPH could come down here and argue under this one line, and a member of the public could argue under the other line.
You'd have to interpret the section as a whole, and that way when you go down to number 4, it would say passive meeting bodies shall not include. So it amends essentially the prior sections to say, yeah, it's any bodies created by these groups or these individuals, but if it's a group consisting solely of city employees, that's to study internal department affairs, which is not expected to modify or change city policy, it's not a passive meeting body. That's just the way you interpret legislation. It's hard.
Yeah. That's why I'm like, that one, passive meeting bodies are such a confusing anyway for everyone. So
Tell me about
That's
it.
why I'm like, maybe if we could just tweak number 4 in some manner.
Well, you can always say that when you draft legislation, you can say anything that falls into category A, B, and C is a passive meeting body. And then D say, notwithstanding the above, which is what this does essentially. Now, notwithstanding what we just said, this narrow category is not included. And so it's a carve out, right? 4 is a carve out. I mean, I don't know if the privacy board is consistent of just employees. It may be of members of the public, and there might be members of the public. I don't know. I wasn't here at the meeting, so I don't know. I don't know how we decided it was a passive meeting body. I don't know what the testimony was about who was the membership. So. And you raise another interesting question. I mean, we've had issues, and I'm not necessarily in favor of this, I just want us to consider it. We've had issues where if a department head doesn't appoint a body, or doesn't create the committee, then there's an argument it's not a passive meeting body.
They tried to use that as a way to wiggle out.
They do. And basically what the task force has said is, if it's a body that's created with the permission of the department head's in charge, right? And so if you're a body and you're doing this significant work, and you're having meetings and all, you really are a passive meeting body. But we've stretched it.
So do you want to put department instead of department head?
I don't know. I mean, that could arguably create.
Well, I think you do, because you say here, do we want to delete department head and use department instead?
That's a question. I'm not saying one way or the other. I think it's controversial, perhaps. I think it might lead to the creation of a ton of passive meeting bodies that aren't currently passive meeting bodies.
Well, that would be a good thing for open government. Yeah, for open government, I think that would be a good thing, right?
Yes, but let's also remember this as we're doing these amendments. There's going to be a fiscal analysis done by the Legislative Analyst's Office of the Controller to say this ordinance is going to create 200 more passive meeting bodies, which are going to now need agendas, staffing, tape recording. Tape recording is not required. Agendas aren't required, but notices are going to be required. So I'm just saying there's a fiscal, in any situation where we say let's have more open government, there's a fiscal impact, and we need to be cognizant of that in terms of looking at the ordinance as a whole, and in terms of the amendments. I can go either way on this. I think this is an issue that we have to look at, and I really need Rick's help on this. I really need Rick and maybe Doug to sit down and really think about what we've done here on this language, because it confuses me. And maybe that's something that we should look at as well. Is this, should we make it just departments, and it would be actually in 1 and 2, because we use department head both of those places. And do we want to say department?
And should fiscal considerations be considerations for us, really?
I think they should be.
We tell the departments it's not. They cry about the cost, and we say, well, that's not our problem.
Because that's what the law requires now.
Right.
But if you're saying we're going to make open government broader, if you're saying we're going to adopt an amendment to make open government broader, I think it is reasonable. The voters are going to think about that when they look at they're going to look at that when they go to see what they're going to do on this. So there's a strategic reason for looking at it. I think there's just a fundamental policy reason for looking at it as well. I mean, we could say that every meeting in City Hall between 2 employees should be open. Could say that.
Work, but, yeah.
Are we in a specific paragraph now, or just the entire passive meeting body?
We are in 1 and 2 under passive meeting bodies.
Okay.
That's where department and department head are mentioned.
Right.
So that's really the question. Should we delete department head?
Okay.
Well, if in the past the task force has interpreted department head to include et cetera, et cetera, et cetera, why change it?
Well, because it's not clear. I mean, it's not. It's an interpretation that doesn't necessarily binding precedent. And it would defeat departments to come in and say, "Well, the deputy director established this committee, not the department head." I just know that's one of the issues we've had time and time again on passive meeting bodies. I have to tell you that my instinct on this is to, even though we shouldn't and we're running out of time, is to continue this section, this definitional section, until next time. Because I really think that folks like Rick and Doug Comstock need to help me out here. I can't do this on my own, and really need to look at this language and figure out what we've done to make sure that we can justify it. Because someone's going to come in and say, well, under this language, the Golden Gate Stables is no longer a passive meeting body, or a lot of the groups that Mr. Pitts looks at, I think, fall within paragraph 5 definition, which we've deleted. So, I mean, I think we really need to focus on that.
Madam Chair.
Yeah.
I'm all for passive meetings, even, I'm all for taking out the word not, actually, in number 10. A passive meeting shall include committee that consists solely of city employees, and for taking out head and one, even if it was a concern, it would create more passive bodies, it would create more work, but I think the ultimate goal of open government as it reaches out is to become more open, and it's going to be really challenging, and maybe the voters will vote on it, and maybe the voters will have to pay for it in some way.
Member Nee?
Well, I think, as much as I favor sunshine, I think the key here is that underlined passage at the end of that paragraph, to study internal department affairs, which is not expected to modify or change city policy. If that's the case, why make that a passive meeting body?
I mean, they're going to say, I'm just playing devil's advocate here. They're going to say, well, the, Privacy Council, we just implement what DPH tells us. We don't create policy. We're meeting every time. We're meeting every week to carry out the policy, but we're not changing policy.
Okay, but sometime down the road, if they do change policy,
Well, how do you define policy? I guess that's the problem. Right? I mean, that's really the problem here, is how do you define policy?
We've gone from passive meaning to policy body to what exactly do we mean by policy?
What, to expect or modify or change policy. I mean, to be honest, the more and more I read this, I'm tempted to leave the definitions the way they were. It seems to be my solution is to except for maybe department head, right? Is to leave well enough alone on this section, because I'm just not sure that we're doing more good than harm.
I think I'm in agreement with you, Madam Chair. I like, except for with the changing department head to department, and then maybe leaving some of the other as it is, just so we can move forward fast enough as we can. I think we might have to make some sacrifices.
Madam Chair, when you say leave it as is, are you saying
Go back to the original.
leave it as is in the current ordinance?
Yes. Because we haven't expanded this section, we've narrowed it.
But you would get rid of that bit of the city and county of San Francisco.
No. Because you have to define employees somehow.
Okay.
I mean, that's my concern. The other issue here, and then we'll move on, because we do have a lot to cover, and time is running on. But this is hard work. This is what we're supposed to be doing. And some of this we didn't do the first time around because we didn't want to do the hard work, and it has to be done. What we've also done is made all bodies created by the mayor policy bodies. And I have to say, I think that's a problem, because now they're not just passive meeting bodies, they're policy bodies, which means they have to have noticed meetings, they have to have agendas, they have to have minutes They have to record their meetings. They have to have those meetings posted on the website within 3 days. It's significant. And I think the problem was that, yeah, that's certainly, the mayor's not going to support this anyway, but that certainly is a problem. Or he may, but I don't want to close down that road. But this is a problem. I mean, it's not a problem, it's an issue. I was not necessarily in favor of this the first time it went through. And then I missed the meeting at the full task force where we discussed these issues. But I think it's something we have to consider. What's wrong with treating them as passive meeting bodies, especially that now that under the ordinance, they're going to have to notice their meetings. Whereas before, they really didn't have to notice their meetings. Now they're going to have to notice it, and hopefully under my proposal, they'll notice it on a centralized city website or web link. So people can find out about them and go. It just means there won't be minutes or recordings, which there aren't now. So anyway, I mean, I think I have an issue with that as well. So those are my issues with this section. It's very difficult. I think there's some significant issues that maybe we're not thinking of that may reduce the number of passive meeting bodies that are covered, and we have a significant increase in the number of policy bodies by saying that basically any committee created by the mayor is a policy body. I mean, maybe it's not an issue. Maybe the mayor doesn't create committees. I don't know. Or maybe he does.
Well, even if he doesn't, the future mayor might.
Right.
Or department.
Well, we know what the departments do. I mean, we kind of...
So I would vote to keep that for expansion reasons. I hear what you're saying, where that's creating like a domino effect. But if we're creating more policy bodies, then they're definitely having more passive meetings.
What?
If we're creating more what is a policy body, then we're definitely having more passive meetings.
Policy bodies can't have passive meetings.
They can't have passive.
Policy bodies can only have policy body meetings, which require all of these other requirements. Now, a policy body, any board created by a policy body is a policy body. Any board created by, or any committee created by one member of a policy body. So if I say, I'm going to create Erica Craven's policy body, Erica Craven's body to study e-discovery, that's a passive meeting body. And if that passive meeting body will then be treated like a passive meeting body, subject to fewer regulations, fewer requirements. It's confusing stuff. Believe me, I go round and round when I read this all the time. So I'm going to do this. I'm going to suggest that we'll continue this as well as Articles 3 and 4 for next meeting. But what we need to do is really think about the groups that have come before us and why we found them to be policy bodies or passive meeting bodies, and whether or not the changes that we've made here are the appropriate types of changes that will increase clarity. I mean, that's one thing we tried to do, is we tried to increase clarity because people don't know what a policy body is. I'm not sure we did that. We narrowed it. Did we provide increased clarity? I don't know. Do we want to strike department head? And do we want to strike other than the mayor, or keep it in there?
Do you think we might want to have a special meeting on all these? Like, if we're going to continue this one, and then we still have 3 and 4 to tackle, maybe.
We may need to have our body may need to have a special meeting in March.
Yeah.
I suggest we do, because if we get through our hearings and whatnot, you know, there goes a good chunk of time, and I'd just as soon have another meeting.
And I would too, so that we could really concentrate.
Okay. Well, then what I will do is I will work with Chris to see if we could have a special meeting on the amendments only the first week of March, at this juncture probably the first week of March, because I'll need to do this homework, but I'll need to do the homework for the rest of the amendments. I've only done it for Article 2. We meet already, I imagine, on the 9th, correct?
Correct.
We could meet Tuesday.
Madam Chair, could you give me 2 dates just to make sure I have the room available?
Yeah, member Nee?
Yeah, we need to be mindful of the fact that March 2nd is the biennial ethics and sunshine training. That's a Tuesday.
Right, starts at 5:30. 5, right? Check-in
I
is...
believe so.
Check-in is between 4:30 and 5 and starts at 5. It's an excellent point. Wednesday, March 3rd?
Yeah, why not?
Should be good for me.
Let's see about Wednesday, March 3rd. And if not Wednesday, March 3rd, Thursday, March 4th? The Thursday's okay?
Thursday works better for me, actually.
I can't make Thursday.
No Thursdays. Okay. But we could do Monday, March 1st. Mondays? Mondays? You won't be
The
here.
rest of you will be.
Well, Member Golden won't be here. Let's just see if March 3rd works, and if not, then we'll have to cut one or both of you.
Yeah.
But we wouldn't want to do that, so.
How about a Friday?
Friday night, we could do a Friday night meeting, people.
I'll do it.
I'll do it.
Yeah.
Oh, yeah, I
Just,
do.
All
just
right.
this once.
All right, let's try for the 3rd, people, and if the 3rd doesn't work, we can ruin our Friday night.
That's fine.
All right,
They make more.
thank you. And it may be that, and by that point, we will know what's on our agenda for the 9th, and if our agenda on the 9th is light, then the special meeting may or may not have to deal with everything. It can maybe deal with a subset, because we'd be able to deal with some of it on the 9th. All right. Okay, so I think we should leave this section now, but those are the issues that we really need to think about. It's a huge issue. It's kind of one of the biggest things we have to deal with. But before we leave the definitional section, 67.3, I'd like to propose a new section, and I've thought about this. This is something I've been wanting to do all along. We have various sections regarding notice and agendas and different time frames for each and different posting requirements for each. And what we really wanted to do was to make something consistent. And so if our current revisions, if you look at 67.4, which is passive meeting bodies, B, we've said passive meeting bodies must be formally noticed 72 hours in advance and be posted at the main library and on the city's website. A similar requirement is required for policy bodies, except it's a little bit different. It's still 72 hours in advance, but it is, the requirement is on 67.7 under agendas, and the agenda shall be posted at the main library and in the branch libraries, and also outside the meeting room as soon as practical, but no later than the start of the meeting. And then there's another provision that deals with posting further on that requires posting on something that's a little bit ambiguous to me. It is on, let's see. .6 is each policy body shall designate one or more, and this is new, it's not noted as new in our provision, but it is new. This is one of the things that Chris needs to fix. G and H are both new. Each policy body shall designate one or more posting locations for notices and agendas required by this ordinance. The Sunshine Commission shall be notified in writing and shall maintain a master list of such designated posting locations. Boy, what a pain in the butt that is. wouldn't it be better just to require everyone to post it on a centralized location on the city website? So that's why my suggestion is to combine all these to make them consistent, so that posting of notices, posting of agendas shall mean the following. And that's my suggestion here on the first page of my memo. I apologize, I don't have pages on this. I will do that next time. And that reads, posting shall mean the following with respect to posting of notice and agendas of meetings, the policy bodies or passive meeting bodies. All notices and or agendas, because passive meeting bodies don't have to do agendas, for policy or passive meeting bodies shall be posted at least 72 hours in advance of the meeting on a centralized location on the city's website where the date, time, and place for each meeting is listed. So, I mean, it's a new requirement. Basically, every clerk or secretary or staff member will have to basically access the website, and the city will have to create a space on the website that will list all meetings. But to me, that would be a huge benefit, because then a member of the public can go to one centralized location and find out, what's happening in City Hall today, or when is this group meeting, and they'll be able to find it in that one area. Then 2, all agendas for policy body meetings shall be posted at least 72 hours in advance of the meeting on the policy body's website. That's limited to policy bodies because passive meeting bodies likely do not have websites. All notices and or agendas of policy or passive meeting bodies shall be posted at least 2 hours in advance at the main library. That's consistent with what we provide now. And 4 is all notices and or agendas shall be physically posted outside the meeting room as soon as practicable, but no later than the start of each meeting. That is only in the ordinance in a couple places. So that's what I'd like to do, is just to make the posting requirements in one area, create the need for the centralized website, which we had kind of talked about in 62. We talked about in various places, but it would only apply to policy bodies in one situation. This just makes it clear that it applies to all. And
it's easy enough to comply with.
It should be. I mean, it's technologically, it will be a pain, and there will be a training. There'll be a spot set up, a form will have to be set up that has live links to the agendas and notices. It's not hard.
They can do that.
It should be very doable. And each person who does this will have to be trained on how to upload it, as they will have to be trained on how to upload their audio of their minutes, which is going to be required by fiscal year end, we've heard, or be capable of doing by fiscal year end. So, I mean, these are issues, but I think they're relatively minor considering the upside, which is something we don't have now, which is a centralized list of when groups are meeting and where in City Hall.
That'd be a great service.
And so as a result, then we would edit 67(4)B, and we basically take out the information about where to post, right? Just because we wouldn't need it there. We'd take out in 67.7, the same thing. And 67.7C, we take out the same thing. And then we delete 67.6G, which is the one that requires everyone to notify the task force administrator where they're posting, because it's just not necessary. That creates make work for something that's going to be accomplished by the centralized website. So that basically is the first 2 pages of my memo.
I have a suggestion. I'm wondering, for E1, for example, all notices and/or agendas. I'm wondering if we could rearrange this information so we can avoid and/or, because that requires the reader to remember that all passive meeting bodies don't require agendas. And so put maybe all notices and deal with notices, and then deal with agendas for policy.
Well, the issue is that there can be notices for policy bodies too. Like, for example, if there's a special meeting, I think you can have a notice without an agenda if you're continuing an item, for example. You don't have to do a new agenda if you create a special meeting. I'm not 100% sure about that, but that was kind of what I was trying to avoid. It gets very confusing.
I know, but I'm wondering, so, but if you say that any notice at all has to be available 72 hours before here or here, okay, and that's just any notice.
Right.
And then agendas are just for policy bodies, and look at that separately. I just, when you,
Right.
and/or it puts a burden on the reader to try to figure out when does this apply and to whom.
It does, but to the extent that a passive meeting body has an agenda, I want them to, not required to do it, but they're encouraged to do it. So if they do have them, I would like them to be, if they do it as a like say I'm the privacy board and I do agendas.
Maybe you could say if available, put a clause in.
And one way you could do is just to break it out. If you really are opposed to the and/or, I particularly am not, but if you're really opposed to the and/or, we could add in all notices and agendas for policy body meetings. 2, all notices and agendas
If available.
and agendas if, it's not really available, and agendas if
Provided
created.
or if created. I like that better. I mean, I don't personally mind and/or. I'm just thinking about. Right.
So all notices and agendas for policy meeting bodies is 1, and then the rest of the sentence. New 2 is all notices and agendas, comma, if created, comma, for passive meeting bodies shall be posted.
Do we want to say if, or do we want to say when? They're not might be required, but if it was when, then that's more of an encouragement, right?
When is more ambiguous to me, because, I mean,
When they're created, I have to post them when
What
they're
date?
created,
Right.
or
Right.
72 hours, yeah.
yeah, I would probably leave it as if. We could use more words, but I mean, that doesn't help either. Does that make sense?
I was wondering about the main branch library. You're referring to the main library, right? So shouldn't that be capitalized because it's a specific place in the city? Yeah, whatever.
Main library.
Main
Yeah.
branch.
Is it?
Its branch would be branch.
Oh, I don't know if it's called the branch. Isn't that just the main library, right? It isn't a branch. The branches are.
To the main branch, though.
But I don't think that's its name. I think we ought to be clear what its name is.
We use it as main library, 100 Logan Street.
Main library, yeah.
I was
Would
asked
library
that
be
one, man.
capitalized?
Yes.
I
If
would.
we're referring to that one,
All right.
yeah.
All right, then main library it is.
Where's that old guy when you need him? Library users person?
Oh, right, yeah.
He would tell us.
About 10 minutes, he'd tell us.
All right. And so then you can see the revisions that would be necessary for 67.4B and 67.7 are listed there. We had, and this we had, and I believe Mr. Warfield had suggested this, on page 2 of my memo, it's under 6C, we had said, and the branch libraries, but then we said, posting at the branch libraries is satisfied if the library is a computer upon which members of the public can access the city's website to search for agendas and meetings of city policy bodies. And the reality is that all branch libraries have computers that have a link to SF.gov. So I don't think we need to state it. I'm not aware of any city library that doesn't have at least 5 public computer terminals and free Wi-Fi.
And if in future they didn't have computers, we couldn't require them to, couldn't make that a requirement.
Well, we could.
Well, we can't be telling the library they have to go buy a computer.
Yes, we could. I don't know if it would be wise, but we could.
At any rate, I like the brevity.
I mean, just think as a practical matter, that's where we are. It's a huge component of the library's budget is to provide these computers, and by and large, they do.
I like the brevity here, just short and sweet. The agenda shall specify time and location of the meeting.
Well, because we took out the rest of it, because
Yeah,
it's already
I like
addressed
that.
in the other one.
Yeah.
Do you have any concerns, Rick?
Yeah, yes.
Okay. Former 67.4 B, which is located, where is that located?
Moved it to 24.
No, it wasn't yet moved. That was the problem. 67.4B. It is on Chris's new version. It's on page 9 and 10. It starts to the extent not inconsistent.
Bottom of page 9.
Yeah. This, we had said, let's move it to 6724, which deals with access to records. But upon further reflection, I think it probably stays better here. It really deals with meetings. It deals with records, but it's records related to those meetings. So in retrospect, I think it should stay here. It doesn't happen that often, but it did come up to, for example, in one of the Arts Commission issues, because there was a building that was owned by the city, but the program was being run by the private nonprofit, right? So I think it does happen occasionally.
We'll just leave that where it is.
So I would reinsert it, but I would call it E, as I note. And then, as I say, we should put in under this section as opposed to in subdivision A, because we've revamped how it runs. So that doesn't make any sense. So it wasn't a section we were going to delete. We were just going to move it. But I think actually it makes more sense to keep it here. It basically means that the governing board of the organization has to run its meetings as passive meetings. Agreed?
I agree. I agree.
67.6.
All right, so the next change is
Title.
67.6. It's purely a title change, just to make it consistent with the changes we've made to the other sections. It should be policy bodies as opposed to policy body.
Okay, done.
And this is where now?
67.6?
On page 10.
Page 10.
Chris's item.
Instead of policy bodies, it should be policy bodies.
916.
Like 67.4 is passive meeting bodies.
Yeah.
And 67.7 is policy bodies. So that's just the change for the title.
So which one are we going with, singular or plural?
Plural, to make it consistent with the other ones. Um, 67.6 This is one of those consistency things that we needed to address that no one else has picked up on. 67.6D is that we need to delete passive meeting.
Policy.
It should be meetings of bodies. So we delete passive meeting and then delete advisory twice in D.
Now, in your notes, you say you want to call it, replace passive meeting bodies with policy bodies. Now
No, I
you're
just
saying-
say these bodies are considered policy bodies. So we don't need
So just call them bodies.
Yeah.
Meetings of bodies. Okay.
as specified in those two sections. Now, of course,
And then take out
if we amend those two sections, we'll
And
have
then
to
take out advisory.
re-amend this. Exactly. Take out advisory, the two places it's there. Because they're not advisory bodies. They're policy bodies.
It's easy enough.
Okay? Purely typographical, 67.6F.
It's policy.
It should just be removed. 67.6G, that one just needs to be deleted. We don't need it anymore. Its purpose will be accomplished by the centralized posting. Actually, don't go so fast. 67.71 on page 17 and 18. I have no idea how this happened, but for some reason, we decided to do A, 1, 2, and 3, as opposed to A, B, and C. But there's absolutely no reason. It should just be A, B, and C. So we just need to make that A, B, and C. That was grilled into me as a law clerk. They're like, you don't need a subsection unless you have something following that subsection. So there's no reason to have the A, 1, 2, and 3 if there's no B. Okay, 67E2, 2, little 2. This is just, that is on page,
15.
which page?
15.
15. That's just a typo issue. The or should come before the little 2. Or grammar, I should say. We good? 67.9A, agendas and related materials, public records. In the first sentence, there's an or, which is not necessary. Or any other documents. So we don't need that or, because there's an or that follows.
Oh, the first or.
Right, the first
Yeah,
or.
the first or, all right. Comma.
And you may have caught some of these in your editing.
Yeah, I may have.
Because some of these are. And then in B, on line, oh good, we already have it in there. Someone already caught it. On line 19, there needed to be a space between is, but Chris has already noted that, as you can see by the double underline.
Mm-hmm.
67.9C. We had deleted, we were trying to streamline by including information in A that we thought was being repeated under B and C. But in reality, the former B has an important point, which is records which are subject to disclosure, which basically means anything that's not for a closed session, and which are intended for distribution to a policy body prior to the commencement or during the meeting, shall be made available for public inspection upon request, prior to the commencement of such meeting, whether or not actually distributed to or received by the body at the time of the request. This comes up a lot. It's a big issue where there might be a controversial report being presented to a body, and there might be a staff report that wasn't ready for the staff packet. It wasn't ready for the agenda packet, so it wasn't in the copy that was posted on the website. It wasn't in the copy that was circulated to people who had asked for copies of packets. But it's ready, right? You know, it's Monday. The meeting's on Tuesday. It wasn't ready last Thursday, so it wasn't in the packet. But it's ready. Some boards treat that as you can hold off on providing it to a member of the public until it's actually distributed to the board members. And the answer to that is
At the meeting.
right. The answer to that is no. It's a public record. If it's ready to go and available, it should be distributed upon request. And so I saw that we kind of inadvertently took that out. I don't think we meant to take it out, but I don't think we accommodated that issue in the revisions. And so I would just suggest putting it back in C, so that C, the new C, former D, but now new C would be edited, not that much, but just to say documents which are intended for distribution or are distributed prior to or during a public meeting to members of a policy body shall be made available for public inspection immediately upon request or as soon as thereafter is practicable, whether or not actually distributed to or received by the body at the time of the request. So it basically just puts back in the import of B, which I think we just omitted by accident. $67.10. Attorney General. I don't know why I thought that was a big deal. It's really California Attorney General, not even State Attorney General. I think he's the State Attorney General.
Box next to me, however you want to play it.
I mean, I don't know. I don't think it's a big deal, actually.
Ordinance. I think we should put California.
Right, because Chris's point, it's a local law, so we want to make it clear that it's going to the state, the California Attorney General. Which makes sense, because in some states and other counties, we have district attorneys, but sometimes they're called attorneys general. So, I mean, different states have it differently. I think in California it's pretty clear, but I think what Chris should do is just go through the ordinance and search, and every time the word Attorney General comes up, just make it sure it says California Attorney General.
Find and replace, will do that.
Yeah, throughout the ordinance. $67.11.
Refers to 67.8.
6711, where is that? Right, I think 67.8 is still 67.8. I just want to make sure it didn't change. So that should be fine. That's fine, nothing needs to be done about that. That was one of those notes I'd made myself like 6 months ago. 6712 is something that we've added in. F, review of closed session justifications. And I actually have another change on this, or suggested change, that isn't reflected in my document. On page 32 of Chris's packet, or the new packet, F1 was a little bit ambiguous to me. The end of it said, for each closed session, each policy body shall maintain a record of the date and time of the closed session, the justification for the closed session, and the subject matter discussed in closed session, and shall include all minutes, recordings, or other records. That last bit didn't make any sense to me. I think what would be better is to say, after discussed in closed session, comma, as well as all minutes, recordings, or other records submitted for consideration in the closed session.
Okay, it's a little more clear, certainly.
Because it didn't really make sense
More
to me.
descriptive, yeah.
What I would say is, comma, as well as all minutes, recordings, or other records submitted for consideration during the closed session. Or should it?
Sounds like the minutes were minutes that were submitted for consideration, not the minutes of the closed session.
I see what you're saying. No, you're right. See, this is why it's good to have more than one person thinking about this, because it's really easy to overlook those things.
It's saying shall include all minutes as well as minutes and recordings as well as other records.
And shall include all minutes, recordings, and other records related to the closed session? It just needs something on the end there.
Oh, okay, related. Yeah.
And shall include all minutes. And, oh, I think actually comma should, maybe this is the problem, is the include. There's nothing to include. I guess the record could include it. But it should say, and shall, see, that's the problem. Do you see what I'm saying? So what if we said, each public body shall maintain a record of the date and time of the closed session, comma, the justification for the closed session, and the subject matter discussed in closed session, as well as all minutes, recordings, or other records related to the closed session. Is that okay? Okay. All right. And then the only other thing is that we should just make it clear that it's 30 calendar days. Under F, no later than 30 calendar days following.
Somebody will claim working days, sure enough.
Right, just trying to make that clear. All right, the next one that's not on this list, unfortunately, because I just saw it today, is 6713F, which is on page 34.
Would the charter be uppercase C?
Pardon me?
Would the charter on line 24 be uppercase C?
Yes, I believe the charter should be uppercase C. I think what this is boards and commissions enumerated in the charter. It should be boards, commissions, and other bodies enumerated in the charter to make it consistent with the prior definitions. Shall by 2012, let's say, because it's already 2010. By the time this is enacted, it'll be 2011, one hopes. So I think 2012 is the correct date. Broadcast all meetings held in City Hall on San Francisco Government TV channel, and then what I would say is parentheses, or its successor, parentheses, or the city's website. Via real-time audio and a real-time, oh, there's the and/or, sorry, remember Washburn. Real-time audio, video streaming, and then
And/or is fine there.
you can delete on the internet because we've already accommodated that. So you don't have to use SFG TV. You can use the city's website for live streaming, real-time streaming. This is different. I mean, there have been, we'll talk about them in a minute, but we have already Supervisor Mercarini and we have made it mandatory that the digital recordings be submitted on the website. But that's within 72 hours. This is live.
Wow.
So, I mean, it's a big deal.
Yeah,
Maybe we should do 2013, but it's a big deal. So anyway, 2012 is the minimum we should do.
Yeah.
Okay. Then 6713E. Where's that? Oh, that's right above there, actually. We had taken out, and in a calendar year in which the city cost of the city for providing translator services exceeds $20,000, the Board of Supervisors shall, as soon as possible thereafter, review the provisions of this subsection. We took it out because we didn't like the fact that we were asking the Board of Supervisors to look at it. We took it out because it had never been a problem in terms of exceeding that expense, but it also was limited to the Board of Supervisors, and now we're providing it for all policy bodies. So I actually think that we need to keep some limit, especially as a political matter. I mean, it's doubtful that it will happen, that will exceed that limit, but I do think it makes political sense to say there should be a limit. I mean, I will
Do we limit?
defer to other people. But it caused me some concern on rereading this section.
But do we have other cost concerns throughout here? Really?
Do we? Not really. There's the outside counsel
We
provision.
don't.
I don't think we do have cost considerations.
Well, then we shouldn't for this then.
Well, this
too.
was in the ordinance. It is right
Oh.
now. Right now, it's in the ordinance.
Well,
And it's limited to the Board of Supervisors. So what we're doing is we're saying, expand it to everyone and take out the fiscal limit. And maybe that's what we want to do. Not everyone, but all policy bodies. But I just wanted to raise that. I'm fine to leave it the way it is. I just thought we should
I think if you
think about it.
If you start to limit it and somebody wants a translator, that's a loss.
Well,
I need a translator because I'm deaf and we've hit the $20,000 limit. Sorry. I think that for litigation purposes, we should be careful about putting a limit on what we provide to citizens. It may.
I think it would probably only be a litigation risk if they started to provide them and then didn't. And so, I mean, we're creating the litigation risk by making everyone do it. So if the members are fine leaving no limit and striking that and leaving it as is, that is fine by me. Okay.
that would be my preference,
Okay.
yeah.
Yeah.
We're going to leave it with all policy bodies?
Leave it with all policy bodies.
Okay.
That's
In that
staying.
case, the word "its" should be changed to "their," THEIR.
Where is it?
Second line, line 8, each of their regular meetings.
Excellent point.
And all meetings of their committees.
Yep. I didn't catch those. Next is 6714. And what we have here is that we have D. But D has essentially been preempted by Supervisor Mercarimi's legislation. So what I've suggested doing is replacing our D with this D, which is basically Supervisor Mercarimi's legislation, but it captures and cleans it up. And expands it a little bit. Instead of boards and commissions enumerated in the charter, it's all policy bodies. So it does expand it, because we had all policy bodies. So Supervisor Mercarimi just says boards and commissions, but what we say is all policy bodies. So for example, under Mercarimi's legislation, our task force meetings have to be put on the website, but not the compliance and amendments. Under our legislation, the compliance and amendments has to be up there also, because it's a policy body. So that expansion was already in our revisions. So this basically just incorporates it, that new thing.
Now, how do you think that'll fly with his office?
Well, actually, I take it back.
Others or not?
You know what? I take it back. His does apply to every city policy body. Actually, his is broader, agency or department. So his is actually broader than ours. The narrow thing was that the one I changed was this subsection D shall not be construed to limit in any way or modify the duties created by any provision of this article, including but not limited to the requirement for recording closed sessions as stated in subsection C, because actually that is now above us. And for recording meetings of policy bodies as stated in subsection B. So I take it back. I'm just making it more consistent by taking out boards and commissions. Because we had B had been limited to board and commission. So his basically is as broad as ours. It's just actually, I think ours is more consistent. So that was the suggestion. 6715. This is another one of those ones that goes back and forth, forth and back, back and forth, forth and back. Needs to be fixed. We've already tried to fix it once, as you can see. Here's where the issue is, and this is what I think needs to be changed. It's the following. The first sentence of B we've stricken, but that actually needs to be in there. Because what A deals with is general public comment. What B deals with is that the same thing as the Brown Act, but it's important. Every agenda for meetings, special keeps reappearing there. It should not reappear. It needs to be deleted. Every agenda for meetings at which action is proposed to be taken on an item shall provide an opportunity for each member of the public to directly address the body concerning the item prior to action thereupon. So that's the counterpart to general public comment. That's public comment on each action item. And then it does flow. However, in the case of the meeting of the Board of Supervisors, the agenda need not provide. That one's fine. That one can stay there.
They had opportunity at a committee meeting, yeah.
Exactly. That should stay as is. And then C, I don't know why C is broken out. C should really just be part of B. because C is only about B. C is not about
C.
A. I mean, C is about A, but it's really about B. Does that make
So
sense?
just meld those two together?
So just put C at the end of B.
And delete the C itself.
Yes. This is one of those other examples why it's so important to have people reading closely, because clearly we've read this all 3 times and we still kept missing the fact that A dealt with general public comment and B dealt with comment on an item. So, I mean, you know, we're all smart people, but this is hard stuff.
Very hard.
E, which is, where is E? F. It's actually it's G under this version. G. Members of the public shall have access to all audiovisual equipment used by department or policy body for presentations made to that policy body. Look, see, policy body right there is not. Let's decide this once and for all, people. Policy body capitalized or policy body lowercase?
Lowercase.
Then please do a find and search throughout all articles, and please make policy body lowercase. Thank you. For presentations made to that policy body consistent with the time limits provided. Prior notification in the agenda or public notice that a presentation will be made using AV equipment or technology shall be provided, listing the specific equipment. I think prior to that last sentence, we should say, to the extent feasible, because I don't want it to read that, say there's a presentation at the Board of Supervisors, and I'm going to be using a PowerPoint screen, or I'm going to be showing a DVD on the DVD player, and instead I change my mind and actually I want to show it on the computer, through the computer screen. Different mechanism, same result, because I got it downloaded because it was digitally broadcast. I don't want to say that you can't show it just because it wasn't technically listed. I mean, what we really want to do is make this as open as possible, and the real point was Chafee's, former member Chafee's point that he wanted to use the library commission computer and overhead to make presentations and shows, and they said he couldn't. And so he felt while the department could come up and do all sorts of flashy stuff, he was being denied as a member of the public. And so that's the real point here. And notice that it's going to be done on specific equipment is helpful, but it's not, in my view, doesn't prohibit them from using it if they've changed. You know what I mean? I just think that we should be a little bit more flexible in the second sentence, not the first.
Makes sense?
So I would put to the extent feasible there.
Is it feasible, comma, prior notification?
Yes. 6716C. I would just replace working with business. I think that's the more accepted usage these days. It's on line 11 and 12. But I would also, and this is not in my minutes because I saw this separately, if real-time captioning is provided, that section, it shall be posted on the website. I think that actually should be, I think it's good, because I think some people do have real-time captioning that is capturable and is separable. And while it does function as a part of minutes, I think in reality, it's better placed under 6714D. before the last sentence. So if you look at my page 4 of my memo, it would say, inspection of any such recording shall be provided without charge. An appropriate playback device may be available by the city. And then it would say, if real-time captioning is provided at a meeting, if separable, it shall also be posted on the website. And it refers back to the city's website above. And then I don't think we need the city administrator shall assist anymore. We can just take that out. DT or whoever it is that is assisting will assist them. So that's if real-time captioning sentence should be inserted there, and then the city administrator sentence should be deleted. Yeah. We're almost at the end, people. We're almost there. 6718. On line 21, it should be calendar days. I think there's been a problem. Chemo Crossman keeps saying they use working days, so let's just specify it's calendar days. But also, my other suggestion that's not in my memo is under B, what we need to say is any person may petition the supervisor of public forums for determination, insert, whether a body is a policy body or passive meeting body, or whether a policy body or passive meeting body has violated any provision of this article. Because one of the real purposes is to say, is it? What is it?
That was the question I had earlier about how to fix that.
Well, this is one way. They can go to the supervisor of public forums and say, tell me if it's a duck or a horse.
Yeah.
And if it's a duck or a horse, did it violate? Or if I know it's a horse, did the horse violate the meeting? And then my last suggestion on Article 2 is that the last sentence on page 43, what we've said is the supervisor of public forums shall copy the Sunshine Commission on all correspondence pertaining to its duties under this subsection. I think that's too broad. I don't think we need all that. I think the supervisor of public records shall copy the Sunshine Commission on all determinations or other action or their actions on petitions under this subsection. So that basically, if they're accepting jurisdiction, if they are reaching a determination or dismissing it because they feel it's been satisfied, those significant correspondence will be copied to us. But every letter saying, dear petitioner, it's unclear about X or Y, could you state this or that? We don't need every piece of correspondence. That's too much information for our administrator to handle. So, but what we would get is the significant pieces of information. Right.
Okay, a question.
Yes.
Is what's significant clearly defined? Or would that be arguable?
All determinations or other actions on petitions is how I have defined it.
Right.
I would hope that would be clear enough, that would be, here's the significant stuff we're talking about. So that's it for me.
Are forums fora, or are they forums? What's the plural?
Well, that's an excellent question. See, again, this is beyond me.
Or I think it's forums, isn't it?
No, I don't know.
Yeah.
I leave that to Washburn and me. That's beyond
I've
my...
never heard the term
I have to
fora.
review my Latin.
I've never heard fora either, but I was just thinking, if you're going to pluralize forum.
That is beyond me.
This is what keeps me up at night.
So I apologize it took me so long to get to this, but as you can see, it's very difficult in some ways. And so we need to do this sort of analysis for everything else. So in conclusion on this item, what I would say is that for our next meeting, what we can say is 67.3 and 67.4 of Article 2, as well as Articles 3 and 4. And our next meeting will hopefully be on Wednesday, March 3rd. It'll be a special meeting to discuss those issues. Sound good?
Yes.
Anything else on this agenda item? Seeing that, oh yeah.
On Article 4, can I go ahead and lowercase all the commissions there?
Yeah, everything we've said for you to do, like that needs to be like it's typographical, just do that.
Okay. Thank you,
And
Madam Chair.
then, as well as Member Goldman will give you his typos before the end of this meeting, so you can do those with our blessing as well.
Yeah.
Seeing no members of the public, this item is closed. Next item, please, Chris.
Administrator.
The next item is the administrator's report, Madam Chair. I do not have anything to add.
Do we have a lot of complaints coming up?
We have more of 12L issues rather than complaints.
Have you, this is just a suggestion. My suggestion would be that if possible, and if you have the time, that you sheepdog them in advance and try to get the parties to agree whether or not the department's involved, and if the department's willing to get involved, maybe we could avoid hearing it by the full task force. I'm sure you already do that, but whatever you can do to
I'll try, Madam Chair.
tie it down would be great. Thank you. Any comments on the administrator's report?
No.
Any, no public comment. Public comment's closed. No one in the audience. Future agenda items, announcements?
Welcome back, Member Nee.
Welcome back, Member Nee.
Thank you. It's good to be back.
All right. No public comment. No one is in the gallery. The meeting
to
is
adjourn.
adjourned.